Adopt a child, okay. Just forgive me for a moment. Okay. So these amendments outline specific regulations and penalties relating to, is this the one? Surrogacies. Yes, in relation to surrogacy services and the abandonment of children conceived through surrogacy. It emphasises the importance of protecting the rights and well-being of children through surrogacy arrangements and imposing consequences for individuals who abandon such children. The references to the Oviedo Convention, an international treaty aimed at protecting human rights in the field of biomedicine, underscores the commitment to upholding ethical principles and safeguarding in surrogacy practices. By aligning with the standards set forth in the Oviedo Convention, the legislation aims to ensure that surrogacy services are conducted in a manner that respects the rights and dignity of all parties involved, particularly the children conceived through such arrangements. The provision imposing penalties on individuals who abandon children after availing of surrogacy services serves as a deterrent against negligent and irresponsible behaviour that could harm the child or birth mother's well-being. By prohibiting such individuals from entering surrogacy services again, the legislation seeks to prevent further occurrences of child abandonment and hold accountable those who fail to fulfil their responsibilities as parents. The delineation of fines and potential imprisonment for offenders reflects the seriousness of child abandonment in the context of surrogacy and underscores the legal consequences faced by individuals who violate these regulations. By imposing both summary convictions and convictions on indictment options for penalties, the legislation provides a range of consequences based on the severity of the offences and aims to deter individuals from engaging in actions that could harm children born through surrogacy. Overall, this amendment underscores the legislative commitment to protecting the rights of the child born through surrogacy, preventing child abandonment and holding accountable individuals who neglect their parental responsibility in the context of surrogacy arrangements. By combining legal penalties with ethical standards rooted in international conventions such as the Oviedo Convention, the legislation seeks to create a framework that upholds the well-being and integrity of children conceived through surrogacy services. I'll let my colleague in if he...
Yeah. I'm happy to just hear what the Minister has to say to the amendment.
Mr. Donnelly.
Gormagat Cahirlock, and I'd like to thank the Senators for submitting the group of amendments. In relation to Amendment 1, I wouldn't agree with the premise that the adoption application involving a child who is not genetically related is exactly the same as a surrogacy application involving a future potential child who will be genetically related to at least one of the intending parents and possibly both of them. I'm satisfied that we have the balance right as regards the safeguards in place and the requirements to be met by the intending parents as part of the dual approval system for domestic surrogacy in order to best protect the rights and welfare of all parties involved. Amendment 4 would simply duplicate within Section 16 the requirement which is already in Section 17 in relation to AHR treatment not being provided unless the provider is satisfied that there is no potential significant risk of harm or neglect to the child. In respect of Amendment 10, Section 59(2) makes clear that a surrogate mother has the same rights as any other woman in relation to her pregnancy. These include the right to manage all aspects of her health during the pregnancy, and it is not considered necessary to specifically refer to termination of pregnancy here, while the stipulation in Section 26 that any woman shall, as standard practice, only be offered a single embryo transfer also applies to surrogacy cases. On Amendment 11, the intending parents must have received appropriate counselling and legal advice prior to applying for approval of a surrogacy agreement. In addition, Section 56(4) provides for the intending parents to give an undertaking that they shall take all necessary steps to provide care and ensure the welfare of any child born as a result of the agreement, and also that they will apply to the courts for a parental order in respect of that child. Amendment 12 seeks to ban single men from accessing surrogacy. This would be unacceptably discriminatory. It's important to note that a single male applicant would have to be genetically related to the child and have to satisfy the regulatory authority that they meet all of the criteria before their application were approved. Amendment 13 makes an interesting proposal in respect of life assurance. We have looked at issues in respect of life assurance and health insurance in the context of surrogacy. However, it was deemed to be too prescriptive to include such a requirement in primary legislation. Obviously, it's open to intending parents and surrogate mothers to agree between themselves to make arrangements in these kinds of areas. As regards guardianship of children born through surrogacy, Section 7 of the Guardianship of Infants Act 1964 provides that a parent may appoint a guardian to be a guardian of the child in the event of that parent's death. Such a guardian is a guardian appointed by a person in their will. In circumstances where a child has no guardian, it's possible for the District Court under Section 8 of the 1964 Act to appoint a person to be the child's guardian. While it would be preferable for any parent of a child to appoint such a guardian, the existing legislation does not require parents to do so, and I would not propose to impose a requirement on parents of children born through surrogacy in relation to such guardianship that is not required of other people who become parents in other ways. Amendment 14 proposes that only countries listed by the OECD and the DAC can be considered for classification as approved through surrogacy jurisdictions. However, as the relevant section, Section 52, relates solely to domestic surrogacy, this proposed amendment would not make sense being inserted where it is proposed. In relation to the final amendment in the grouping, Amendment 15, I believe that the offences provision in the bill in relation to surrogacy and the requirement for intending parents to get preconception approval from the regulatory authority adequately deals with the concerns raised here by the senators. In particular, it's envisaged that any issue related to previous offences against children or women would be discovered through the safety of the child assessment, and as such I am not in a position to accept the amendments.
Thanks, Mr. Donnelly.
In relation to that particular section, Minister Donnelly, in relation to 15, very disappointed that you won't accept that amendment. I mean, and this applies not just to men, but also to women. I mean, as a foster parent over the years, I can tell you that, you know, sexual crime against children is not exclusively to men, it also is to women. And I'm really, really disappointed that you won't accept that. And actually, it's very disturbing that you won't accept that, particularly someone that's been convicted of a crime against a child. Very disappointed. So, you know, if you are trying to maintain public trust and confidence in surrogacy services, it requires adherence to strict regulations and standards that prioritises child protection and safety. So, by implementing restrictions on individuals convicted of child sexual offences, it demonstrates, you know, a commitment to upholding these principles of promoting transparency in surrogacy practices. Children born through surrogacy are among the most vulnerable individuals in such arrangements. By prohibiting individuals convicted of sexual offences from participating in surrogacy, it helps protect these children from potential harm or exploitation. Allowing individuals with a history of sexual abuse to participate in surrogacy increases the risk of abuse or harm to children born through the arrangement. This restriction serves as a preventative measure to reduce the likelihood of such risks and prioritise the safety and well-being of the child. So, upholding ethical standards and legal regulation in surrogacy is essential to ensure the integrity of the process and to protect the rights of all parties, and that includes the child, Minister. So, prohibiting individuals convicted of sexual offences aligns with these standards and reinforces whatever ethical principles are there, but surely there must be some ethical principles there of surrogacy. Surrogacy should put the best interest of the child, ensure the safe and nurturing environment for their upbringing. By excluding individuals with a history of child sexual offences from participating in surrogacy, it reflects a commitment of safeguarding the child's welfare and promoting a supportive and healthy family environment. In conclusion, the prohibition against individuals convicted of child sexual offences participating in or availing of surrogacy services is a crucial safeguard to protect the interests and well-being of children born through surrogacy. By prioritising the child's safety, legal and ethical standards and preventing measures, this restriction helps uphold the integrity of the surrogacy arrangements and ensures a supportive and secure environment for the child's upbringing. So I'm really disappointed, Minister, that you wouldn't accept this amendment, or that some safeguarding is not there for people that may have been involved in and may have committed a sexual offence against a child, that they would not be precluded from this legislation. I'm very, very disappointed, to tell you the truth.
Senator Keoghan. Senator Mullen.
I just want to make some general points at this stage. In relation to the amendment, amendment number 10, it provides in page 57 between lines and 36 and 37. I just want to get it here because it relates to what I want to say. So, the amendment that would provide that the surrogate mother only should be allowed to decide on any reduction of embryos and must not be obliged by commissioning adults, other agents, to undergo an abortion. Minister, you ran through your responses to various amendments there. I'd be grateful if you would just detail to the House again your rationale for not accepting that particular amendment before I go on, if that's okay.
Sure.
Thank you to both senators. Yes, as I said in my initial remarks, the concerns that the senator has very reasonably raised are already covered. So it is not the case, Senator Keoghan, that there are no safeguards in place and that this would be inserting a safeguard at the last minute. There are, as I'm sure you would support, numerous safeguards which would pick up not just on the offence that you have listed here, but much more broadly. In fact, by stipulating a single offence as you have, which is a heinous crime, and certainly nobody should be considered an intending parent who's been committed of sexual assault against or any sexual crime against a child. There are numerous safeguards already in place for exactly that. There would be a concern that if we begin stipulating specific ones, heinous ones like you have said, that an argument could be made to say, well, the applicant may be guilty of other things which are not listed, but then the courts may not have the discretion. So I do take very seriously the points you've raised, and I want to assure you, and indeed assure anyone who's watching these proceedings and colleagues in the Seanad, that there are layers of safeguards in place to pick up on exactly these things. I think you've gone to some of the most serious, the most heinous crimes a human being could commit. The regulatory authority and the courts will have the discretion on that and much more as well. So I can assure you we have built many safeguards into the legislation. In fact, the entire bill is framed around really protecting, in the first instance, the child and the surrogate, and then the intending parents as well. But it really is framed around the child. The child comes front and centre in all of this. There are numerous protections in place for the surrogate as well, to make sure that domestic and international surrogacy is being done in the right way, that there isn't coercion involved, that there aren't some of the concerns that people have, I think, very reasonably raised involved. So I take your points very seriously, Senator, and can assure you that the protections in place, there are layers of protections in place that would identify that and indeed a great many other considerations as well.
Senator Mullen.
Yeah, I understood that the Minister was going to answer the question that I asked at this point. Could I ask you to answer the question that I asked, Minister, which relates to a different one? If you didn't mind giving us your rationale for not accepting Amendment 10, which I think has been is for discussion at this stage. I realise that it's difficult because there's a lot of amendments here, so I just want to be able to think as I go along here. So this is the amendment that would insert that the surrogate mother only should be allowed to decide on any reduction of embryos and must not be obliged by the commissioning adults or their agents to undergo an abortion, just for the avoidance of doubt. If you wouldn't mind addressing your rationale for opposing that amendment, please.
Yes, Senator. As previously stated, the bill makes it very clear that the surrogate mother has the same rights as any other woman has during her pregnancy.
Thanks, Minister.
Yeah, thank you, Minister. Now, I just feel that because we're in this brave new world here, which I and many, many other people oppose, which involves frankly, a commodification of children as many people see it, and a deprivation of the rights of women Now, I realise we're talking in the context of domestic surrogacy here, but some of the same principles apply to the really dangerous area of international surrogacy. But I think it's important, and we had a discussion about this to some degree last week, and my friend and colleague, Senator McDougall, disagrees with me on aspects of this bill, particularly, on aspects of the objection that I and many others have to this bill. I think it's one of the phenomena of modern times that, in many ways, the contradictions in people's thoughts, that the human embryo is considered something that can be disposed of, that can be created in surplus, that can be experimented on, that can be stored, and that can be eventually destroyed. And the strange thing is that if you look at various international bodies and so on, it's nonetheless still the case that there is a lot of talk about the respect due to human embryos, and this is frequently stated, and yet and there's a lot of concern around practices that are seen as contrary to human dignity, for example, such as reproductive cloning of human beings, and I know that isn't to be permitted under this bill. But this is if you like, the strange contradiction, because at one level there is frequently recourse to language that talks about the respect due for human embryos, while at the same time the practices that are envisaged and permitted under law treat the human embryo as having no respect. And the strange issue is, and I listened to my colleague and friend Senator McDougall last week, where he suggested that my concern about the respect and the protection due to human embryos was rooted in philosophical, or then he added, or maybe religious reasons. And I want to make it very clear that there's a common misunderstanding that goes along the following lines, that if religious bodies have concerns about something, then those concerns can only be understood in religious terms. It's fatuous to suggest that, because an acorn is different from an oak tree, that an embryo is different from a human being. An embryo, if you crush an acorn, you crush an oak tree. If you destroy a human embryo, you do destroy a human being at his or her various earliest stages of life, where you have the full new individuality of a human person or persons. Of course, that embryo may lead to numerous persons being born, if not destroyed. And therefore, the respect due to human embryos is something that really is a scientific and evidence-based position. Whether that's bolstered by kind of religious thought or feeling about the sacredness of human life generally, which informs people's opposition to all sorts of evils, human trafficking and all sorts of other things, in a sense is beside the point. So that's the reason why I think these amendments need to be considered as very important, that embryo reduction is a serious matter. It is the destruction of a human life at its earliest stage. I'll move on to just ask about amendment number 12, Minister, where you this is the amendment that proposes to make clear that no single man shall be allowed to undertake surrogacy. And I think, if I'm not mistaken, your reason for opposing this is that you regard it as unacceptably discriminatory. I think this takes us to some degree into territory that we don't often discuss in these houses, but which certainly came up in the context of the recent referendum, which involved the proposed removal of the term mother from the Irish Constitution in the context of the recognition of the particular role of mothers in the home. And I think it's well regarded now that got up a lot of people's noses, and that was in no small way a part of people's rejection of the particular referendum proposal that it concerns. I think one of the criticisms I have of this legislation is that there has been little to no public consultation with people about what they think about many of these proposals. I think if you ask people whether in general do they believe that as far as possible a child should be brought up by a father and mother, and as far as possible by their own father and mother, most people would say yes to that. There is a widespread recognition that notwithstanding the heroism of many single parents and the support that is certainly due to them from the state, that as a social principle we should be encouraging the bringing up of children by their fathers and mothers. And of course there are many life circumstances that intervene to prevent that. People get, marriages breaking up, people dying, all sorts of tragedies that deprive a child of the opportunity to be brought up by both their father and their mother. But there is a difference between that happening unavoidably and that being brought about intentionally. And I think that's what's at the core of many people's concerns about surrogacy, that it is proposed to deprive a child up front and in advance of the society, of the responsibility due to that child from one of their intending parents. And one of their genetic parents, not to mention the sundering of the child from the woman who has given birth to them and nurtured them for 9 months. So there's major concern about that. But I think if you were to ask people, okay, if we accept the principle, and I don't accept it. I don't accept the principle of surrogacy anyway, but I certainly don't accept the principle that the state should smile on and regard as, completely immaterial whether a child is brought into the world by one parent or by two. But if you were to ask people which would they prefer, that a child would be brought into the world by a single commissioning mother, okay, who for whatever reason is bringing a child into the world using a donor sperm and so on, and or by a single commissioning father, I think most people would say that I think you would have much more opposition to that. And there I think you understand that there is something special in the public mind about the role of mothers in particular. And I'm the first to stress that we need to talk much more in our society about the role of fathers in their children's lives and the consequences to children when they don't have fathers in their lives. And we've been afraid to talk about that in the way we need to talk about it. But at the same time, I think there would be a much greater sense of opposition to the idea that it would be intended that a child would never have a mother in their life. I think there is something profoundly offensive in that, in particular. And I think talk about equality and discrimination just doesn't cut it when we talk about the realities of what is due to a child. And I certainly have no hesitation in saying that if I were to, and this is recognised in all sorts of indirect ways. For example, in our family law, in the context of custody, custody is generally accorded to the mother. There is a reason for that. There are injustices to fathers in family courts, but there is a reason why courts generally accord custody to the mother. So, this kind of sterile language of non-discrimination, while it claims to some kind of virtue, it's the opposite. It's the denial of what most people would regard as common sense. And therefore, I think there should be a public debate about whether it is unacceptable discrimination to say that it's better to contemplate a child being brought into the world by a single mother than by a single father, as is permitted under this legislation and enabled by this legislation. I think we should have a real public discussion about that. And that's the one I won't say criminal, but absolutely one of the absolutely disgraceful things about this legislation is the lack of public consultation. I don't say there hasn't been a lack of careful preparation. There certainly has. It's quite clear that an awful lot of work has gone into the preparation of this bill, but all by people who want to get it over the line and who want to shield it as possible from as many possible objections. So you have the provision in the bill that it will be gestational surrogacy only, that there will be at least one genetic parent among the among those who commission surrogacy. I get all that. And they are slight improvements on what is a bad situation, however. But this idea that it's just unacceptably discriminatory to say that a single man shall be allowed to undertake surrogacy, that it's not acceptable because it's discriminatory, because this bill would allow otherwise a single woman to undertake surrogacy. I think that shows the real weakness of this bill, that you're not actually thinking in terms of children's welfare at all. And that's one of the great tragedies, and I've given out about the children's ombudsman in this House, and I restate my objection to the failures of the Ombudsman's office in relation to this legislation, because while they have commented on it and made recommendations and been heard from, and indeed made certain propositions that I would agree with, such as the idea that where it happens, the child has a right to a relationship with those who bring that child into existence through a surrogacy arrangement. The fact is that, to my mind, the Ombudsman has been criminally negligent by not objecting to surrogacy in the first place and not proposing strategies to prevent it from happening. And here is yet another failure. That the Ombudsman isn't even interested in vindicating the idea that the child would have a mother in his or her life. How any of those who sit in this room with me can just smile on that situation. It beats me, quite frankly. And I tell you one thing, if you put that question to a referendum, 80-20 would vote we shouldn't be enabling arrangements that would deprive a child of a mother deliberately and of ever having a mother in their lives. It leads as well to another question, and maybe, Minister, you would take an opportunity to answer this. And I haven't addressed this in amendments at committee stage, but I hope to address it at report stage. And that is this. Under the provisions of the Gender Recognition Act, a person may have their preferred gender. A male person may have their preferred gender established as female. Now, if that person, having availed of the Gender Recognition Act's provisions to have a preferred gender as female, then decides to engage in a surrogacy arrangement, supplying their own male gamete, which they're still capable of producing, thus meeting the requirement that one of the intended parents would have a genetic link to the child, then securing a donated egg from a party other than the surrogate mother, obviously, because it must be gestational surrogacy only, and then engages the services of a surrogate. And then that pregnancy happens, and then that parental order is sought, and the matter goes to the registrar for registration. And as we know, the civil registration allows for designation as parents, but also the words mother and father are still used. And I'm asking a direct question here, Minister, and I would appreciate a direct answer, because it will inform whether and how I will table an amendment here. Would a person who has availed of the Gender Recognition Act to have their preferred gender as female, having supplied a male gamete and engaged in a surrogacy arrangement, would they then be able to present themselves to all intents and purposes to the world as the mother of that child, having secured a parental order? And would they be registered, and could they be registered as a mother of the child by the registrar, by An Cláraitheoir? I'd be grateful for an answer to that question, please.
Ask for your guidance on this. The question that Senator Mullen has raised is not covered in the amendments we're discussing, but it is covered in amendments 21, 26 and 33 later on. Should we wait until the amendments relevant to the question and discuss it then?
That's okay, your proposal, yeah.
Does Senator Mullen consider it relevant to his amendment?
Does Senator Mullen consider it relevant to your amendment?
Well, I do consider it relevant, but I am happy to wait, Minister. You know, it's a reasonable question and it deserves a careful answer. And I suppose I consider it relevant because I'm talking about the amendment number 12 that says no single man shall be allowed to undertake surrogacy.
Okay.
And I am talking about a situation where a single man, biological male at least, but who may have adopted, have availed of the 2015 legislation to have their preferred gender as female, that they would thereby be enabled as a single man. We are talking about them undertaking surrogacy in that situation, though they may present to the world and have their preferred gender recognised as female. So it is connected, but I'm equally quite happy to wait.
Minister, if you wish to address it now, fine, and if you wish to wait until later, that option is open to you.
Thanks, Chair. No, I'm happy to do it now. Thank you very much. I'm speaking to Amendment 21, but I accept the point that it is related to the current amendment. So, Amendment 21, which is Senators Keoghan and Mullen have tabled, which would essentially say that the mother identified in the parenting order is not the genetic mother of the child, the father identified in the parenting order is not the genetic father of the child. Essentially, my interpretation of where the senators are going with this is to preclude any transgender person from availing of surrogacy. That appears to be the intention. And I guess Senator Mullen is asking directly that question. The very clear answer is yes. Somebody who is transgender will have full rights to avail of surrogacy, as will anybody else. I simply disagree entirely with the proposition that, as a society, we should say a woman on her own can raise a child, but a man on his own cannot raise a child. I fundamentally disagree. I think for me, it's an extraordinarily offensive proposition. It really is. There are men all over Ireland raising children on their own, be it through separation or divorce or bereavement. And they are exceptional fathers, exceptional men. I would find it extraordinary that we would say men can't raise children, or we shouldn't entertain at the start of a family the idea that a man shouldn't be allowed to have a child, but that a woman can, of course, and women do. I would just fundamentally disagree, Senator, with that proposition. You know, it's an interesting one. You talked about women's rights and being a defender of women's rights at one point in your contribution. I would disagree with that characterisation of your involvement in this, I have to say. We've had debates on this, we've had debates on safe access zones. My observation is that you work very hard and very diligently to deprive women of their rights, particularly around fertility. Maybe you do believe that you're here defending women's rights. I certainly don't see it, I have to say. But when it comes to a single man who wants to have a child or children, and surrogacy is the only option available to them, we're accepting it for a woman on her own. As somebody who is pro-life, you know, surrogacy creates more life. It creates more children. It creates more families. It creates more mums and dads. You know, I would have thought that people who are pro-family, pro-life, indeed we're all pro-family, well, it depends on one's definition, I guess. It depends on one's definition. I've rarely met anyone who's anti-life, but surrogacy creates more children who otherwise wouldn't exist. It creates more mums and more dads, and it creates more wonderful families. That's what it does. And whilst I have taken great exception to your characterization around the pro-life debate, I absolutely respect everyone's view on termination of pregnancy across the spectrum. I disagree strongly with you on your characterization of it, but I fully respect everybody's position on that. But I would have thought people who are vehemently opposed to termination of pregnancy, which is a position I don't share but I respect, would be in favour of more children and more life and more mums and more dads and more families. I would have thought. And I appreciate that there is an ideological position, and I appreciate there are some religious institutions who've taken a very public view, and that's fine, and that's fine. But certainly for me, to the Senator's questions directly, can a transgender man or woman under this bill, they will have the same rights as everybody else. Can a man raise children in a wonderful, caring, loving way? Yes, he can, and yes, they do, all the time, all over our country. And surrogacy, I think, there are safeguards we have to put in place. It's what this bill spends a lot of time doing. But what an extraordinary thing, what a wonderful thing for one parent or two parents who have tried to conceive naturally and haven't been able to. And maybe then they've tried assisted human reproduction, maybe they've gone through IVF. You know, they'll have practically bankrupted themselves just trying to have a child. They will have gone through potentially rounds of IVF, which is so difficult for them. It is so hard for people going through IVF. And having done all of that and still not had a child, what an extraordinary gift surrogacy can be, so that these incredible women and men can be incredible parents and raise the most wonderful, beautiful children. So I hope that answers the questions.
I would like to respond.
Well,
Minister, I thank you for your response. There's a number of charges in what you said, and I'm not going to take personally anything that you say there, but you do introduce a note of moral judgmentalism vis-a-vis other people in your comments. I won't up the ante other than to say that I think that your moral and political vision, as exemplified by your conduct of your public role, is very stunted indeed. I regard your approach to this issue as cynical. You rely excessively on emotional argument. You seek to demonize your critics. I seek not to demonize you for sure, but I certainly utterly condemn the way you have gone about this issue, your lack of consultation. There are many things I could take issue with. For example, you talk about ideological and religious, which is a kind of a sneering way to describe an attitude. You use those words, which is what I'm saying.
I'm not sneering.
What I'm saying, I'm regarding that. We will. Yes. No. I just want to address what the minister has said, if I may. I think it's a rather sneering attitude to a position that is more correctly described as philosophical. And we all have our philosophical views. And where I differ from you and where you differ from me is that I believe that human life begins at conception. And I believe that that is a very scientific and evidentially respectable position. Because at that point you have 46 chromosomes, you have new human individuality, and you have momentum towards life. And once you accept that one can sincerely hold that principle, and you say you respect that view, I'll prove to you that you don't, because you refused at all points to meet with a single pro-life organisation in previous times. You have consulted only with those who believe that life is dispensable with after. So it is quite hypocritical of you to say that you respect everyone's views, because you don't. You have refused to listen to or engage with reasonable people who have wanted to engage with you on various pieces of legislation on various issues. You have shown nothing but contempt, actually, for the alternative view. So you tell an untruth demonstrably. Yeah.
Could we deal
we will. No, we will. But
the
now,
amendments?
yes, but I'm only responding to what was said, and I intend to do so. Okay, and I'll do so respectfully. But I have exposed, first of all, that the minister's words are not borne out by reality. He has not shown respect for alternative views. He then goes on to say that that the position of underlying the amendments here are suggestive of the fact that whereas I believe a woman on her own can raise a child, a man on his own cannot. That, of course, is not what I believe, and it's certainly not what Senator Keoghan believes. And it is not what the people who oppose surrogacy believe, and it's not what many people who have concerns around some of these legislative initiatives believe. In fact, if you were listening to me, I talked about how heroic single parents can be and how they often deserve a much greater level of support than other situations, and indeed often deserve a much greater level of support than what they get. But it's not today nor yesterday that governments here have decided that there's going to be no hierarchy in terms of the social vision of families. And those were words actually used by a former minister, Francis Fitzgerald, during a debate on the children and family relationships legislation. But if you say there is no hierarchy, you know, what you are saying is we may never express a social preference for ideas that most people would consider core and reasonable. And as expressed by myself earlier, which is that as far as possible, a child should be brought into the world and raised by a father and mother, and as far as possible by their own father and mother. Now, you disagree with that proposition, but most people disagree with you about that. It is common sense, which, as many people have said, isn't that common anymore. And to say that it is more desirable that a child would be brought into the world by a father and mother and by their own father and mother is to do no more than to observe what is natural in our human condition. Of course, there are situations where that isn't possible, where life circumstances make it impossible. And we don't shun or stigmatize people in that situation. We rally round and we give them even more support. But we don't abandon our social vision. Most parents, thinking of their children growing up in the future, if you ask them what do they want for their child, would they like their child to bring a child into the world on their own, or would they like them to be in a stable, long-term, loving relationship where children are? Anybody with a titter of wit would say that the latter situation is what you would aspire to and what you would hope for. And the reason that makes sense is because we're not talking in this legislation about what unavoidably happens. What unavoidably happens, tragically for some, is infertility. That I get. What is unavoidable for single people is that they can't bring children into the world on their own. That I get. What is unavoidable for a same-sex couple is that they cannot bring in a child into the world on their own. That I get. What is inevitable is that that will be a cause of sorrow and sadness for them. That I get, and I sympathise. But my position is that if you take children's rights and welfare seriously, you don't put the aspiration of adults in as the priority. You operate for what is in the best interests of children. And you don't and shouldn't intend and foresee the deprivation to children of things that are considered fundamental and normal and good, like the society of a mother in their lives. That is basic. Like the society of their birth mother who brings them into the world. That is basic. Like the society of both of their, and the responsibility of both of their genetic parents. That is basic. It may not seem basic because we have travelled a road where over years now, and over many different pieces of legislation, we've been giving adults what they want. And we give adults what they want, partly because politicians are weak and unprincipled, and they are susceptible to NGOs, lobby groups, who can talk about their own pain, and their own pain deserves sympathy and a response. And where you have a compliant media which refuses to ask the hard questions of all sides, and which refuses to say, well, who are the unwitting or the unwilling victims of these arrangements if we make them? For example, like the surrogate woman internationally who is exploited for her poverty, to advantage people who have resources. That's the unprincipled political outcome. It's the perfect storm of where you have unprincipled politicians and a compliant media, highly vocal advocacy groups, the reality of their pain and suffering, which should never be dismissed, and which should be acknowledged and which should be sympathised with, but also the invisibility of those who lose out as a result of the arrangements that are proposed. The woman in the Ukraine is invisible. And that's the reason why we are not saying, Minister, contrary to what you said, that a man on his own cannot raise a child. Many of them do, and heroically so. The issue is, should you set out to deprive a child of ever having a mother in his or her life? And that is profoundly wrong and unjust. And it proceeds from a stunted, perverted vision of human rights that ignores the rights of children.
Keep it relevant to the amendments. That
yes, I'm being very relevant. I am talking about amendment number 12, if it's any support to you, Cathaoirleach Ganevig, and why it matters. And therefore, when the Minister disputes my assertion that I am concerned for women's rights as part of this equation, his basis for saying that is that I disagree with abortion. But I actually disagree with abortion partly because it hurts many, many women, and of course many unborn children are killed. That's your only basis for suggesting that my credentials on women, that I don't depend, thankfully, on your good opinion anyway, Minister. But I can tell you that it is you who is dishonouring women's rights in this legislation when you enable the victimisation of impoverished women in poorer countries through the provision of international surrogacy. Yeah, and it is.
You're gone off the amendments again.
I'm coming to the end of my point. I'm not here to go on longer than I have to, but I'm here to answer in full each charge that has been made there. And it is you, Minister, who dishonour women's rights when in your legislation you refuse to acknowledge that a child should never be deprived of a mother. And that is exactly what happens here. In surrogacy, the child is deprived of their birth mother, and where single men are allowed to commission a child, or indeed a same-sex male couple, you are deliberately depriving a child of ever having a mother in their life, and that is a scandal. And that will not stand to your good reputation when we look back in history or when others look back in history. The final issue that you raised, Minister, you are proud to champion the fact that a transgender person may become a parent through surrogacy. Well, I'll confine my concerns about that to the issue of where a single transgender person, a male with gender dysphoria, who has a preferred gender of female under the 2015 legislation, brings a child into the world using their own sperm and then presents themselves to the world as that child's mother. I mean, what planet are people on if they think that's acceptable? And here again is you not respecting women's rights, because if you really respected women's rights, you wouldn't allow that situation, that you would have a male person being the sole commissioning parent of a child to be born through surrogacy, doing so using his own male gamete, and then presenting himself as that child's mother. That is not fair on the child. It is not fair It's not fair on the individual themselves, the transgender person, the person with gender dysphoria. But here again, you do all this in the name of equality. But this is colour by numbers at this stage. You're taking previous bits of legislation which were ill-advised in themselves, and now we're coming to the ever more chaotic conclusions of those previous bits of legislation. So I can't persuade you today, Minister, to see how wrong-headed you are. I can only put it on the record that you are no champion of women's rights in this legislation, if ever you were. And certainly you should think again. You should think again about enabling any kind of surrogacy arrangement, whether involving a transgender person or otherwise, that would intentionally would foresee the deprivation of a child of ever having a mother in his or her life. That is just wrong.
Senator O'Loughlin.
Thank you very much, Chair. And I just want to object and say myself that I feel Amendment 12 is completely wrong. It's gendered, it's discriminatory. And while Senator Mullen was speaking about single men not being allowed to undertake surrogacy, he also mentioned gay men in a partnership or in a marriage. And one of my neighbours at home in Kildare, Brian Dowling, very well known, himself and his husband Arthur have already a daughter through surrogacy, through domestic surrogacy, through Brian's sister Aoife, and they're expecting another baby. The love, the joy, the happiness that that family exudes, and all the different support measures that are in place. I honestly don't believe that anybody would go down the surrogacy path if they didn't have supports in other ways, through friends, through family, through a support network. And I really object to what the Senator has said. He has spoken about this being a philosophical argument. Well, you know, Cicero, Socrates, Confucius, and indeed Buddhism all talk about the importance of parenthood, all talk about the importance of family. And I think it's, you know, while there can be a philosophical background or support to either side of the argument, what we're talking about here is practicalities, and it's about giving practical supports to those who wish to be parents and wish to give love and wish to give support to children that hopefully may come into their lives. And that's why I just wanted to make that point and speak against Amendment number 12. Thank you.
Senator Siri Kearney.
Thank you, Cathaoirleach, and thank you, Minister, for your robust rejection of these amendments. I'm going to go through all of them because and point out the errors in the conception, pardon the pun, of all of them. The first is in Amendment 1, the idea that parents entering into surrogacy should be on a par and meet the criteria of adoption. It is to conflate surrogacy and adoption, which are very different things in the journey to becoming a parent. It is to not recognise that one or both will be the biological parents of the child. It is also a failure to understand the fact that perhaps the adoption process actually needs to be reformed, and it is to set it up as some champion of a pathway to parenting when it is deeply flawed in many instances. The fact is, a lot of people who go down the surrogacy route may have cancer and be in remission, be told they're very healthy, be 20 years along from perhaps their original cancer diagnosis, but because of those original diagnoses, they are denied the opportunity of adoption. They go through a process where they're told or called out into a room, having gone through the various stages of adoption, to be told there is going to be a weighting put on your ages based on the particular illness that you have once had or perhaps are at risk of ever having again. And consequently, that putting them out of being eligible for adoption. Many surrogacy parents have already faced into the horror of a process where you put in an application and they contact you 4 years later to invite you to start engaging in the process. And then when you're in the process, to be called out to say, this is an impediment, you would win, but you'd have to go to a judicial review, we would have to reject you. You go to a judicial review and maybe you'd overturn it at that stage and make yourselves eligible for adoption. And then we need to also look at the success of adoption as a route to parenthood. In fact, the shame that there are so many million children in the world who would be absolutely fantastically within a family, but adoption is, to my mind, no longer fit for purpose and hasn't been for a very, very long time. So to equate the two is to be ignorant as to the reality of adoption, and to conflate two completely different routes to parenthood. Amendment number 4 smacks of a statement that Selena Bonney made to the Disability Matters Committee on International Women's Day in 2021, where she and her husband were going forward for IVF, for fertility treatment. And she was told, she was a disabled woman and unfortunately died earlier this year. But she was told that she could only undergo and engage in the fertility treatment if she could guarantee that her child wouldn't be disabled. So there is an inherent discrimination within that statement in Amendment 4 that discriminates people with disabilities, that obliges them to prove that their child be able-bodied or able and not be disabled. It is really quite appalling in its wording, and I gladly reject it. Similarly, so all of the sentiments within it are not appropriate at all to this discussion. Then we move to Amendment 10, I think, is it? Or am I missing something? Amendment 10. So let's just, for a start, dispel some of the myths that are going on here. As long ago as, and it feels like an eternity ago, when Micheál Martin was the Minister for Health, but as Minister for Health, he asked the Commission on Assisted Human Reproduction to produce a report. That report was finally published in April 2005 after an incredibly long and detailed process. It recommended a regulatory authority, exactly what's in this bill. It recommended the legalisation of surrogacy, exactly what's in this bill. They had 23 plenary meetings, they had several working groups, they went into this in depth, and none of them were, they were all professionals, they were all people who were in a position to have a so-called objective opinion. Not that there's anything wrong with being subjective, as I am accused of, because actually that's the nature of democracy. Hey, members of the House actually reflect the real life of people in Ireland. But as long ago as 2005, that's 19 years ago, this was spoken about. So this has been in the public discussion for over 19 years with a recognised, respected report sitting on the public shelf for digestion. So the idea that this is suddenly something new or never consulted about, then we had 2012, Alan Shatter's list of proofs for court. Then we had the PLS, the pre-legislative scrutiny of the Assisted Human Reproduction Bill of 2017 that led to the committee saying, actually we need to do something different around international surrogacy. We need a detailed, we need to examine that further. Then we had the commissioning of Conor O'Mahony, the Special Rapporteur on Child Protection. The clue is in the name. And he came out with his report in December 2020, and it was published in spring 21. It formed a basis for the International Surrogacy Committee, the Joint Oireachtas Committee. That Joint Oireachtas Committee heard from across the board, including the Ombudsman for Children, who came and presented to the committee. Now, Niall Muldoon does not need me to stand up for him, but I do want to say, as an individual in public life, as the Ombudsman for Children, the man is filled with integrity. His reports often tell us off in government, often challenge us. He's certainly no puppet of anybody, and an amazing champion for children. Following last week's charges by Senator Mullen, I forwarded him on the most recent email from the Ombudsman for Children on this, so that he was aware. But the Ombudsman for Children's submission and the entirety of that meeting of the International Surrogacy Committee is there and available in the public to see where their positions are. So, you know, we come on, then we come to this bill and the hours, and I know I've exhibited impatience over the last couple of years because I'm on the front line of people's reality and the challenges in their lives. But, you know, here we are at an incredibly well thought through piece of legislation. And as I've raised issues and challenges, I am ever impressed by the sheer depth of discussion that has gone on in the answers, and the three people here with you, Minister, are particularly in that. So we need to remember that the recommendations of the committee were all about trying to conceive a legislation that enshrined the Verona Principles. So let's just remember where the Verona Principles came from. So they are the international, an international organisation, 100 years old this year, that have worked with the United Nations, that put down the original 12 recommendations that laid the groundwork for the convention, the International Convention for the Adoption of Children. So we're dealing with an incredibly reputable body, and we have incredibly reputable people who signed those principles and who recommended those principles. People of huge international standing who had the imprimatur of the UN in setting out those principles. And one of the core sentiments and views and the advocacy of those principles was the idea that the surrogate mother would always have and hold bodily autonomy. We discussed it at committee, at the Surrogacy Committee. We upheld the idea, absolutely, that she should have an absolute say over her own body throughout. And be that she may choose at some point, that she may choose abortion herself, that she may choose the termination of the pregnancy herself. All of those, so it's not just about her having a termination imposed on her, that she may choose it, that she may reject it, but that she had at all times the say in the bodily autonomy, respecting her right to do that. The best practice in embryo transfer and recommendation and for supposed success rates in IVF is actually the transfer of one embryo. Not any more than that. 2 would be the norm, but 1 embryo is actually now, and that's talked about in this context in the bill. You know, and that causes hardship to some people who feel that the more that are transferred, the better the chance. Actually, it works contrary to that, and that the environment of the uterus is best placed to nurture a smaller amount of embryos transferred. Embryos are very treasured by surrogacy families. In some instances where women have been obliged to have hysterectomies, the HSE for a long time now has supported before any cancer treatment, if they are to run the risk of infertility as a consequence of their treatment. The HSE has prompted the storage of eggs, the harvesting of eggs in advance of any treatment. The HSE has funded that for a long time. in actual fact. And even the HSE has shipped embryos in such circumstances to locations where surrogacy is to be carried out. There's at least one mother here today who has had the benefit of that. So the preciousness of embryos actually is at the heart of this. You know, for many, they will never have their own genetic embryo again. So nothing is disposable here, not in this. So it's not about using emotion. It's actually about using fact. It's actually about stating the facts of our lives, the facts of our society, the facts of our experience. So amendment number 10 is not necessary for a start, because everything in the legislation not only responded to the report of the International Surrogacy Committee, but actually went further than that in many instances. Some harshly, that would be disagreed, and that's where the argument in the lower house was it wasn't liberal enough. But many was really about the fact that everybody wanted an ethical framework, and basing it on the Verona principles and on the autonomy of the surrogate mother is a very important one. The idea that there has to be an amendment of testamentary guardians, isn't that the next? Are we on to 11? Any surrogate parent. I'm not quite sure who the surrogate parent is. Is that the surrogate mother? Is it the intending parents? So the terminology in that amendment is incorrect. Demonstrating that they understand the risks and effects of their decision. Well, enshrined in this legislation is counselling, is legal advice. In fact, any of us who have been before the courts have already had to put in affidavits and proofs that the surrogate mother knew what they were doing. So again, it demonstrates a misunderstanding of the actual process that families are going through and that surrogates work with in order to arrive at a place where consent to parental orders, such as they are at the moment, are given. So number 11 is not necessary. And then we come on to the contentious number 12. I suppose in this journey, I have had the honour of meeting lots of people, but I have met men who all of their lives have, and in my general life, who all of their lives have dreamed of being parents. It's not down to their sexuality that they want to do that. It's just down to a inherent human instinct to want to have a child. I was deeply impressed by the testimony given, particularly by Garoj Kenny in the surrogacy committee, where he talked about their first date with his husband and their absolute desire to talk about, well, would they have children? Just as my husband and I talked about on our first date. So the idea that your gender somehow includes you or excludes you is really appalling, from that inherent human desire to have a child. I've also sat with men over my adult life whose partners have just had a miscarriage and cared for them in that pain, in their loss, and they nobly move to support their partner who is going through the physical experience of a miscarriage, but emotionally they feel the loss. Emotionally, they too have had all of the dreams of a lifetime that goes with however long a pregnancy lasts for, and however short it might be. They have, there's an ad on the television at the moment where they're buying a child's shoes, going to school, and they click into that idea of a father practicing his speech at his daughter's wedding. Men have those wishes, have those desires, make excellent fathers. It is the presumption that is behind that amendment is really quite appalling. It is a terrible indictment on men, which I fundamentally and absolutely reject. It also makes an assumption that every mother is a brilliant mother, is perfect, that we're all, you know, we're all, what is it, the American term of, you know, what is it, apple pie and cream, you know, we're every mother within one of the signatories to this amendment is herself a foster mother, should know when it breaks down, should know that that's not the case. And there are various reasons, and nobody is to blame for any of that, but the idea that there is one gender that's perfect and should be a parent, should be allowed to be a parent on their own, and that's it, and that men shouldn't be allowed to be a parent on their own, that's appalling. You know, that's an appalling sweeping statement and presumption about all men, regardless of their sexuality. Amendment 13, I unusually, it's probably one of the few in the entire thing that I have sympathy for. You know, the idea of life assurance is, I agree with you, Minister, it's too prescriptive for primary legislation, but certainly it is something that should be considered, the life assurance. But adding in about the new guardians, that parents should put in guardians for their surrogate children in the event of death. Actually, people do that. Actually, when you go to your solicitor, testamentary guardians are one of the first things that you're recommended to do once the process here is confirmed. So that's something that can be advised by the regulatory authority at the material time of anyone making an application there. Also, many of us had to go down the route of making sure we, as the second parent, were the testamentary guardians for our husbands, the biological fathers of our children, and that goes for same-sex and opposite-sex couples. So, you know, that is something that, again, it's a misunderstanding. The basis of that amendment shows a misunderstanding of what is involved and how everyone approaches surrogacy and approaches the responsibility of becoming a parent and the seriousness with which they engage in this process. 14, I don't really have a comment on. I think that's a matter for the ARA, how they deal with who should be, you know, what clinic, what country, how that should be done is a matter for the regulatory authority. Amendment 15, I want to first of all support you, Minister, in saying that under no circumstances is anything, and any reading of this legislation clearly demonstrates that people accessing fertility treatment actually have to go through a screening process that's set out in this bill that's deeply offensive actually to people who need to access fertility treatment. I've already had words over here with saying, seriously, so what? You have a diagnosis of fertility treatment, and then you have to that you are infertile, or there is some element of your life that's infertile, and then you have to prove yourself in order to be accessed a medical treatment, a scientifically available treatment. That people, because what? We get a diagnosis of infertility, and all of a sudden we have to prove we're upright human beings, that and that is in the bill. I think it's quite harsh. There was much discussion at committee stage in the Dáil on it, but I do appreciate it is a best practice standard, and I appreciate it actually goes to the sentiment of putting a child first. And ensuring the best interests of the child, but this correlation between infertility and having to prove yourself to be a decent human being is really needs to be challenged and pushed back on, if in sentiment, if not in actual practical legality in this legislation. And in it, The idea, so part of that screening is going to be all sorts of criminal offences. You know, someone who has been convicted of dangerous driving, it shows themselves to be demonstrably unsafe to have a child in their car. There are a whole heap of things, a whole heap of convictions that will be considered, a whole heap of circumstances that will be considered. There's counselling that has to, there's a whole raft of safeguards. But let us get to the fact that what needed to be said in this is that no one who is convicted of a child sexual offence, either inside or outside the state, should be allowed to participate in or avail of surrogacy services. You see, I think the sentiment behind that amendment is one that casts aspersions on anyone who enters surrogacy. It's a sweeping statement that we're to be suspicious, we're a stereotype, particularly if you're a gay couple. It goes to a stereotype that I would have thought we have long since extinguished. And anyone who proposes to put it forward, or anyone who proposes to bring it into the general aspersions. What?
Did you want?
Yeah.
Point of order, so.
I find the accusation made by the Senator really unwarranted. Unlike many members of the Senate in here, I have had 122 children in my care over the years, and many of them would have been victims of child sexual abuse, perpetrated on them not just by somebody male in their family, but also somebody female in their family. And that amendment was put down today with only the interest of the child. Only the interest of the child. I've stood up here many, many times in relation to child protection in this chamber, Senator Carney. And you know that.
Siri Carney.
Siri Carney, Senator Siri Carney. And you know that.
I'm sorry,
and how important that is for me. And in fact, if I go back to who you quoted earlier on, you quoted.
Can you conclude your point of order, Senator?
Professor Conor O'Mahony, and he actually.
Conclude your point of order.
Sorry, but I mean, I'm counteracting what she has said.
You can reply to the debate afterwards.
That's fine.
Can we hear from Senator? Have you more to continue?
Yep. So I don't deny that there's child sexual abuse. Not at all. I don't deny it. But I'm just curious. Arbor Hill is where most of our sex offenders and rapists are held. Are we moving to make sure that none of them ever father a child again? Are we making sure that anybody who can, in their full fertility, have a child? What are we doing? Are we moving to a place where we think we have a right now to say and to prescribe that anyone I agree with the sentiment. Nobody who is convicted of child sexual abuse should be anywhere near a child. That isn't the reality of the real life. So putting it into the context of surrogacy, I object because there is an inference about our families. There's an inference about same-sex male couples. There is an inference about a man, a single man. There is an inference and an aspersion cast in this debate that is appalling, that undermines the integrity and the ethic of anyone who enters into this space. So the minister and the officials in crafting, and the legislative drafters, have crafted a series of safeguards to ensure that anyone guilty of such a heinous crime doesn't go through, doesn't get into fertility treatment, let alone surrogacy. But why say it? In all of those years, and I completely accept, I have heard, amid all of the other very right-wing sentiments in here, I have, though, heard the truth of Senator Keoghan's experience as a foster mother. I have heard that. I have always had deep respect for it. But their children, I guarantee you, I doubt one of those 122 children were children born via surrogacy, just for a point. I doubt that to be the case. And we have systems in place in this country to deal with it. So the idea of us, I don't think it needed to be said. It's part of a besmirching and a throwing dirt on families because what? Even the terminology that is used. You know, the terminology that's used. It is okay to have a different philosophical perspective. It is, of course it is. I would respect and defend the right of people to have a different philosophical perspective. But I do not defend their right to impose that on other people to the point of exclusion, to the point of picking and choosing who should be a parent. And if you desire to be a parent and you go down a medical science route and you ask for, as I have done for 10 years, for a framework of legislation to make sure that it's ethical, make sure that everybody is safeguarded in the process, especially the surrogate mother, and more especially any child. I have asked for all of those things. So any aspersions here should not be accepted, and I reject them. And if they're not intended, well then so be it. And I will accept that they're not intended. But I do need to say it, because in many of the discussions and in many of the anti-surrogacy environments, there are terminology used, there are attitudes portrayed, and individuals who clearly are very vulnerable are trotted out to tell their story and exploited for the anti-surrogacy argument. They are exploited in this. To cast aspersions that any intended person is a type, and I reject that. Because intended parents are not a type. They're human beings who all of their lives have desired to be parents. Be they gay or straight, be they a same-sex female couple who have the right to that lifelong relationship with their children, and those children with both of their parents, be they a same-sex male couple, be it a single woman, or be it a single man. And I note, I had a quick look there on the TUSLA website for fostering. And in the TUSLA website for fostering, they invite single people. They invite single people to come forward for fostering purposes, for the care by the state of children who are their most vulnerable. So TUSLA want to recruit single men to become foster parents. You don't have to be a parent already. So why shouldn't a single man become a parent via surrogacy? What we are doing here is not looking back to a philosophical position that also denied divorce, that also still categorises the couple in a second marriage as being adulterers, that also denies contraception, that also denies gay couples, that also condemns lifestyles. We are moving to a place of a society and making a decision on our society that is inclusive, that reflects the needs of parents and families, and that ensures that anyone involved in that process is going to be safeguarded and cared for. And we're doing so in excellently thought through legislation. I'll leave it for there now.
Thank you, Senator Mullen.
Thank you very much, Chairli Gneevy. Can I just say one thing at the outset? I listened to every word that Senator Siri Carney said. I always find her sincere and I always find her impressive. I think she's wrong on a number of things she said. But I will say this, she was allowed to speak quite rightly without any interruption from the chair. And I just want to say that I insist on the same treatment for myself and for Senator Keoghan as well, because during my equally long intervention where I tried to address all the points that had come at me, I was interrupted several times by the chair. And I demand equal respect for all sides in this House from the chair. I just want to put that on the record quite clearly. There are a number of issues. I want to return to something I didn't address when the Minister was replying, when he exhorted people who see themselves as pro-life to see that surrogacy entails the bringing into the world of new life. Just to be very clear, once a new life is in being, that life takes precedence. Respect for that child takes precedence. That's why pro-life people are opposed to abortion. It's why I agree with the limited contribution of the Ombudsman for Children when he said that once you have the situation in being under the Convention of the Rights of the Child, the relationship between the child and the parents who have brought them in to being through surrogacy arrangements, that there has to be a recognition of that right for the sake of the child. My view is that that should be addressed through guardianship and through ancillary legislative or regulatory mechanisms that ensure that the child is in no way disadvantaged. However, I also believe that in order to discourage it from happening prospectively, that there should be penalties for where people engage in surrogacy arrangements, because it is against the interests of future children. Now, this distinction between, I suppose, where the test of the child's best interest comes into play was commented on by Professor Conor O'Mahony when he talked about the application of the best interest principle, that really it's to be something that addresses the real life circumstances of an individual child rather than to the hypothetical circumstances of unidentified children. And I take that point, and that's why I support, as I say, measures that allow for the recognition of the relationship in being between the intending parents who have brought a child into the world through surrogacy, as that being in the child's best interest. Now, I think that best interest, as I said, can be achieved by recognising the legislation for the individual rights of the children and, as I said, for providing for a position of guardianship. But I do think that there needs to be penalties, as I said, for those in order to prevent it from happening in the future. And it was Professor Conor O'Mahony who I think said to the Oireachtas committee, and I pitied anybody who had a dissenting view, by the way, who was on that committee. I'll make that point in passing. But I think it was Professor O'Mahony who said that almost all international surrogacy arrangements have a commercial dimension at play. How else are you going to identify a surrogate internationally? I don't know whether he's at peace with what the government has done. I haven't consulted him on that point, but I'd give him credit for having said that much. But I stand by my criticism of the Children's Ombudsman for failing to call out this and what's going on here, because it seems that for the Children's Ombudsman and so many other children's rights advocates, the child's rights only begin once the adults have got what they want. Heaven protect us if it should ever become the fashion to deprive children at the embryo screening stage to be brought into the world of a limb or something else that could be achieved through the horrors of modern science, because it seems that the best that the Children's Ombudsman's office could say in that situation is that the children should be enabled to have prosthetic limbs once they're born, but that they have nothing to say about the circumstances in which they're brought into being. So let's be clear, the child's rights should take precedence from the beginning the child's life happens. But what happens, how children are, it cannot be logical to say that because you're pro-life and you respect all human life, that you can never have quibbles with the way a child is brought into being. For God's sake, we all condemn coercion in sexual relationships where that leads a child to be brought into being. The child is innocent of the wrong circumstances in which they were brought into being. And what we're saying here is that surrogacy arrangements intentionally deprive the child of certain things that a child should always be considered entitled to. It is suboptimal to bring a child into the world knowing that they will never have mother love. It is suboptimal to bring a child into the world in a way that intentionally deprives them of ever, for example, having access to their mother's breast milk, okay? It is one thing for these things to happen normally and naturally as a result of life circumstances. It is another thing to put your own desire for parenthood ahead of what a child is entitled to expect, whether that child is in being or not. And anybody who denies that there are real human rights concerns being expressed here is in cloud cuckoo land or is in absolute denial. Now, Senator Siri Carney talks about people's dreams and people dreaming of being parents. I completely sympathise. But in life, we don't always get to realise our dreams at the expense of others, nor should we. And that's what's going on here. People are being enabled to realise their dreams, their very natural human aspiration, but to do so and to have it realised in a way that does injustice. First and foremost, to the women in the context of international surrogacy who are exploited in their poverty. And this is just horrendous, that any first world civilised human rights respecting country would allow this, knowing that a rich woman, you don't find them carrying babies for poorer women. You find poorer women in their economic disadvantage grasping at this opportunity to make money for financially advantaged people. And that we would smile on this by regulating it is just shameful. So it isn't about people's dreams, as important as people's dreams are. There is something more important. And we can't just, you put a whiff of incense on all of this by saying we're regulating it and we're determined to do it in an ethical way, when what we're doing is fundamentally unethical. Senator Siri Carney talked about the preciousness of embryos. But again, I thought of Alice in Wonderland and how, words mean whatever I describe them to mean. How can you talk about the preciousness of embryos when this very legislation contemplates the screening out, the destruction of, and the experimentation on human embryos? And then to say, oh, but we all, of course, at the heart of this is how precious we realise human embryos to be. I'm sorry, but that is not the reality of this legislation.
Thank you, Senator.
Okay. We're using a term here, suboptimal, which is to presume that there is a circumstance that is optimal. So optimal in Senator Mullen's proposition is a mother and a father. However, optimal is also not to be born into poverty. Optimal is also to have an opportunity of education, an opportunity of a whole heap of things. So if we decide on what optimal is, then are we moving into a position of eugenics? Are we moving into a position of deciding that whole swathes of our society shouldn't have children? They shouldn't have children because they have a fertility issue that can be overcome by science. But let's not regulate for it. Let's just ban it because it isn't optimal. And it is that position of what is optimal is merely a philosophical statement. It is maybe well held, and sincerely held, but it is a philosophical position. So to refer to anyone else's family and arrangement as being suboptimal, I absolutely and categorically reject.
Senator Mullen.
Well, Senator Siri Carney has raised a very fair and important question. She makes her point, as I said, eloquently as always, but I disagree but we are getting to the important core of this, because she also meant, and I meant to talk about this actually in my response, where she said that we can't assume that every mother is perfect, or she suggested that there was an assumption in our amendments that every mother is perfect, etc., etc., etc. And she talked then about circumstances where nobody is to blame. Well, sometimes there very much is somebody to blame when motherhood or fatherhood is imperfect. And by the way, I don't deny for a minute that there can be suboptimal parenting. In fact, one could say by definition, all a human experience is suboptimal, because we all fail, we all fall, we all fail to be our best selves at times, However, the question is, do we then say that everything is relative? Do we then say that nothing may be insisted on as essential? And I think that is the big failure here, because it isn't just a philosophical view that says that children do better when brought up by a mother and a father. You know, there's all sorts of social evidence on marriage, for example, on to do with educational outcomes, attitudes to law, involvement in criminality, drug taking. So much social science that points to advantages that children have in certain family situations. And we can't be in denial about reality and what's truthful, okay? And therefore, it isn't just the expression of philosophical opinions which may or may not be right. There's actually an evidence base for much of what most people believe about what's ideal or to be preferred for children. There is evidence that children do better if they're brought up in two-parent families. There is evidence that, you know, that fathers' absence from children's lives can be problematic and can be associated with social problems and so on and so forth. Ask any family lawyer, ask any judge in the children's courts, okay? So there's lots that we can say that is true or probably true. The idea, though, that we can, you know, completely relativize maleness and femaleness. And this, of course, is at the heart of gender ideology and queer theory, that it doesn't matter if you're a man or a woman, it doesn't matter if you're male or female, there's no real difference. This is what was at the heart of the recent referenda as well. There was a clear mission to relativize fatherhood and motherhood and to play down the significance of those concepts, of those ideas, of those basic necessities. But nature speaks more loudly than any of these ideological propositions. And what nature, backed up by evidence, shows is that it's good for children to be brought up by a father and a mother, and where possible, their own father and mother. And even if you didn't have social science pointing to the benefits for children, the very fact that the child has certain rights here, we can say that a child has a right not to be deliberately deprived of their genetic parent in their lives. A right. That's what makes, you know, sperm and egg donation so problematic, because you are deliberately bringing a child into the world in a way that intentionally deprives them of a genetic parent. That's what makes surrogacy so problematic from the child's perspective, in that you are depriving the child of the right of the birth mother who has nurtured them for 9 months. Who here is willing to say that there is no bonding of any significance that goes on between a birth mother and her child during the time in the womb, and that we're absolutely certain that there are no future traumas, you know, that would be involved either for the mother or for the child as a result of that sundering? Who here could take the book, or if you're a secularist, make your affirmation and say it absolutely doesn't matter? You know, we even know in the field of epigenetics that the birth mother and her biology can contribute, even if she's not the genetic parent of the child, to certain future realities for the child. You know, science is telling us so much that I suspect the proponents of this bill would rather not hear. So nobody is claiming that a father can't be a good father and if he's bringing up a child on her own, or indeed that a mother can't be a good mother if she's bringing up her child on her own. But that does not mean that you would deliberately deprive a child in advance of ever having a father in their lives or of ever having a mother in their lives. That is to put parents' or adults' aspirations first by relativizing the goods of fatherhood and motherhood. And it is a selfish thing to propose, because it doesn't put a child's best interest first. What it does is it says, well, the child can at least be glad they're alive. Well, I'll agree to that. Yeah, it's better that a child would be alive than dead. But are we really saying there that it doesn't ever matter in what circumstances you bring a child into the world? Or subject to what disadvantages or disability? Or subject to what genetic pre-interventions? Is the child just supposed to be glad that they were brought into the world? You know? We know that that's wrong in the case of non-consensual sexual relationships. We can't justify the bringing into being of a child there, although we can certainly never ever justify the killing of the child there either. You know? The contradictions are all on the side of the proponents of this bill. you know, because they don't have a record in defending a child's best interests from the moment that they're conceived. You know, our position is to defend the child's best interests right from the get-go of their lives, and to say that even before a child is brought into being, they shouldn't be intentionally disadvantaged in the way that we have described. And of course, we have pointed to the abuses of women that are intrinsic to the whole process, particularly in the context of international surrogacy. Thank you.
Sir? Fine. You're fine? Okay. The question is amendment number 1, the name is Senator Mullen. Are you pressing the amendment?
Now, if we can bring it forward and then adjust it forward. I think we won't press that amendment at this point.
Not pressing, you're withdrawing.
Can I just say, Kelly, because it was discussed, in relation to amendment number, and I meant to just say it was the amendment number 21 that did get touched on, and the Minister...
It's not part of the group.
No, but the Minister spoke to it. And I just want to say...
But you'll have an opportunity later on.
Yeah, I only want to say one thing, which is that it's incorrectly drafted and it's in error, and it will be brought forward in a more correct form at report stage. Thank you.
Okay, so amendment number 1 has not been pressed. The question is section 2. Is the amendment been withdrawn?
Withdrawn, yes.
Withdrawn. Is that agreed? Agreed. Okay. Question is that the section 2 stand part of the bill. Is that agreed?
No.
Not agreed. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I believe the question is carried. Section 3, amendment number 2, in the names of Senator Mullen and Keoghan. Can I ask, are either of them moving the amendment?
Withdrawn. Is that okay, Sharon? Yeah, withdrawn.
Withdrawn.
Yeah.
Not moved, so. Okay.
Amendment. Sorry, I think was it moved? Oh, sorry. Moved. Sorry, can I ask the assistance of the Secretariat here through the Chair? We may move, withdraw, and then bring forward at report stage if we deem fit. Is that correct?
Yes, if it arises out of committee proceedings.
Yeah. Thank you. Yeah.
So you're moving and withdrawing.
Withdrawing. Thank you.
Okay.
Yeah.
That agreed? Agreed. Amendment number 3, in the name of Senator Keoghan and Mullen, is out of order because of a potential charge on the revenue. The question then is that section 3 stand part of the bill. Is that agreed?
Agreed.
No.
Not agreed. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I believe the question is carried. Section 4, that section 4 stand part of the bill. Is that agreed?
No.
Not agreed. Question is that section 4 stand part of the bill. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I believe the question is carried. Section 5, that section 5 stand part of the bill. Is that agreed?
Agreed.
No.
Not agreed. The question is that section 5 stand part of the bill. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I believe the question is carried. Section 6, the section 6 stand part of the bill. Is that agreed?
No.
Not agreed. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I believe the question is carried. Section 7, the section 7 stand part of the bill. Is that agreed?
Agreed.
Those in favour say Tá. Those against say Neil.
Neil.
I believe the question is carried. Section 8, that section 8 stand part of the bill. Is that agreed?
Agreed.
No.
Question is the section 8 stand part of the bill. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I believe the question is carried. Section 9, the section 9 stand part of the bill. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I believe the question is carried. Section 10, the section 10 stand part of the bill. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I believe the question is carried. Section 11, the section 11 stand part of the bill. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I believe the question is carried. Section 12, the section 12 stand part of the bill. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I believe the question is carried. Section 13, the section 13 stand part of the bill. Those in favour say Tá.
No.
Tá.
Those against say Neil.
Neil.
I believe the question is carried. Section 14, the section 14 stand part of the bill. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I believe the question is carried. Section 15, the section 15 stand part of the bill. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I believe the question is carried. Section 16, Amendment number 4 in the name of Senators Mullen and Keoghan, already discussed with Amendment number 1. Is the amendment being moved?
Yes, that amendment is being moved.
Is it being pressed?
That amendment is not being pressed.
It's been withdrawn
with the leave of the House.
Okay, is that agreed? The question is that section 16 stand part of the bill. Is that agreed?
Agreed.
No.
Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
Believe the question is carried. Section 17, that section 17 stand part of the bill. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
The question is carried. Section 18, that section 18 stand part of the bill. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I believe the question is carried. Section 19, that section 19 stand part of the bill. Those in favour say Tá.
Tá.
Those against say Neil.
Neil.
I believe the question is carried. Section 20, Amendment number 5 in the name of Senator Mullen and Keoghan. Amendments 5, 6 and 8 are related and may be discussed together by agreement. Is that agreed? Agreed. Can I ask, on Amendment number 5, is the amendment being moved?
Yes.
Do you wish to speak to it?
Do you want to speak to it, Sharon?
6 and 8 together.
Well, I'll just get started by drawing the House's attention to the amendment, okay, which is it provides that in page 34. In section 20, provisions supplementary to section 19, that there be inserted the following provision. You know, just say that I'm in the right place. Yeah. That any potential or relevant donor shall be required to sign a declaration demonstrating they understand the risks and effects of their decision. And this shall include a legally binding commitment to care for a child in the event that they are disabled or don't possess certain characteristics. The declaration shall clearly outline that there is no power differentiation between the commissioning parent and surrogate parent. The declaration shall also include a legal binding obligation stating that surrogacy is not being entered into for profit by the surrogate parent or other relevant parties.
Minister, do you wish to respond? 5, 6 and 8.
Gormagath Cahirlock, and can I thank the senators for submitting the amendments. All three amendments appear to relate to surrogacy, whereas the relevant sections each proposes to amend are not primarily or at all concerned with surrogacy. So I wonder, maybe there was an intent to insert them in a different part of the bill. Amendment 5 seeks to amend section 20 of the bill, which is concerned with the consent of donors of gametes for use by others in any donor-assisted human reproduction procedure, not just a surrogacy agreement. Amendment 6 seeks to amend section 37, which is concerned with the screening of donors of gametes or embryos for use by others in a donor-assisted human reproduction procedure. Amendment 8 seeks to amend section 43, which is concerned with posthumous assisted human reproduction, something that is not permitted to be provided as part of the surrogacy agreement under this bill. But regardless of the question as to whether the amendments were intended maybe to point to different parts of the bill, donors of gametes for use in any assisted human reproduction procedure or in any surrogacy agreement must consent to not having any parental rights or responsibilities in respect of any child born with the use of their donation. Therefore, there is no question of a donor entering into a legally binding commitment to care for a child. Furthermore, this is in line with the current approach in Ireland as per the provisions of the Children and Family Relationships Act 2015, which was commenced in May 2020. Thank you.
Minister, Senator Mullen.
Just thank the Minister for the reply. I'll take a look again at the positioning of things, and we'll take a look. We'll be withdrawing them by. I will be requesting in a moment to withdraw them by leave of the House. But I might just make a couple of quick points that are relevant here, and maybe ask the Minister a question. First of all, the question is, and it is well worth our considering, what should the obligations of a donor be? Where a person gives their own gametes for use in assisted human reproduction, including but not confined to surrogacy arrangements. As I have said already in this House, I believe that a child should not intentionally be deprived of the society of, a relationship with, and a responsibility to them from any person who has a genetic link with them and are indeed from a mother who carries them to birth. I believe that that is an obligation to the child, okay? Because in the vast majority of circumstances, aside from rape or sexual abuse situations, the giving of one's gametes in the creation of a new life is a voluntary act, okay? And we, mature human beings should live with the consequences of our actions. That's core to being mature. That's core to being grown up. To me, there is something fundamentally wrong with promoting or enabling an attitude that a person can give up their gametes, their own genetic identity, and know that those gametes will be used in the engendering, if that's the correct word, of a child, and then have no responsibilities in regard to that. Now, of course, that is the logic of the brave new world we have entered into, and not just with this legislation, but previously with recognition of the begetting of children using donor gametes. But to my mind, it is a matter of essential truth and natural law, if you wish, that where a person voluntarily or willingly allows their gametes to be used in the bringing into the world of children, that they should not, that they should have responsibilities, actually, and all those, donor sperm givers. I don't know why, by the way, they're all from Nordic countries. I hope there isn't anything racist involved in those particular choices. But who knows? And it's not for those of us that oppose it to have to worry too much about what's going on or why people choose donors from particular countries. But it certainly seems to me that if people understood that the donation of their gametes could carry civil consequences for them. For example, that any child born of their gametes might have a right to some provision by them in the future. Then people might have second thoughts about donating or indeed selling, as undoubtedly happens in the world, their gametes. So I think there's a real question there about, what should the obligations of an egg or a sperm donor be. And there may be circumstances that I can't think of off the top of my head where they shouldn't be held to have some kind of responsibility towards the child, but I can't think of any such circumstances where they freely and voluntarily enable their gametes to be used in the bringing of children into the world. I'd also say that raises the issue as well, while we are talking about donors, about what do we consider appropriate, or who do we consider appropriate to bring children into the world. Of course, it's in the normal course of human events, it's not something that we need to engage with, because people do what comes naturally and children are born as a result. But where we legislate and presume to regulate the process whereby children are brought into the world, and we give thanks for that little voice that was brought into the world at some point in the not too distant past, it's certainly appropriate to ask about what is the past of that person, what might the intentions of that person be, and so on. And that is something that I will return to, if I may, later on in the context of amendment number 15, which has already been discussed briefly.
Thank you, Senator. Can I ask, are you moving, Senator Siri Carney?
Just one thing on that. It has been said about the possibility. I just want to give a piece of information to Senator Mullen about Nordic countries and donor gametes. The fact is that that couples can have their own ethnicity reflected in in donor when they go into fertility services, be they perhaps from an Asian ethnic. There is a whole range here. So just lest there be anything left on the record of the House to presume that everybody is going for some sort of a particularly racial profile. That's not what goes on. Actually, the services are offered for, and the storage happens to be because of an ethical perspective in some of the Nordic countries that they work with Ireland. But it would be wrong to presume that any of them fall into a particular classification of Caucasian or otherwise.
Thank you, Senator Mullen. Are you moving amendment number 5? Are you pressing it?
Amendment number 5. Yes, I'll move it, please. Oh, sorry. There is one other thing I would like. I would like to say this as well. I didn't touch on the issue of disability, but this is something maybe that I might ask the Minister to assist me with here. So, in the event that a child is the subject of a surrogacy contract or a surrogacy agreement, and in the course of the pregnancy it emerges that the child has a disability, and sadly in the world we now live in, it's considered acceptable to end the life of that child where they have a disability in many jurisdictions, including our own, where the disability has a certain level of severity. Is it the decision of the surrogate and only the surrogate? Is it only the surrogate who may seek to have a termination of pregnancy, and is the surrogacy agreement in any way allowed to provide for consultation or of input by the commissioning parents into any decision in that regard?
Yes, sir. Thank you. The question has nothing whatsoever to do with the amendments. Should we proceed, or?
Well, I just say to the colleague, it does, because we're talking about what happens to a child in the event that they're disabled or don't possess certain characteristics. So, I mean, I'm just asking for assistance here, Minister, about what your bill proposes. So, if you prefer to give it to me at a later point, fine. If you want to specify that point, that's fine. But it's a reasonable question and it deserves a reasonable answer.
Thanks, Senator. As previously stated, the surrogate will have exactly the same rights as any other woman who is pregnant.
So, does that mean that there is no and can be no input from the intending parents who are engaging in a surrogacy agreement into any decision about whether a child who turns out in utero has a disability lives or dies?
The surrogate will have exactly the same rights as any woman who is pregnant. So in the same way that no person can interfere with any pregnant woman in terms of the choices she makes, the same situation will apply to the surrogate.
And does that mean that is there a legal prohibition on there being any stipulation or any change in the agreement around monies to be paid or conditions in the surrogacy agreement? Is it prohibited that even if it's entirely the surrogate's decision in relation to the continuation of a pregnancy, is it the provision of the bill that decision will not and cannot interfere with any of the provisions of the surrogacy agreement and their operation?
Do you want to give us an example? It's quite a theoretical question.
Well, if there are provisions in the surrogacy agreement, presumably it provides for the payment of reasonable expenses and so on. Are there other elements of the surrogacy agreement that might depend on whether the surrogate has the child or not? Could there be elements could there be elements of the agreement that would depend on whether the surrogate has the child or not? I'm trying to establish, could anything operate to overbear the will of the surrogate mother in this situation?
I'm struggling to... You might be able to give us an example, Senator.
I'll return
again,
to it.
all I can tell you is the surrogate mother has exactly the same rights as any pregnant woman. The only part of the surrogacy agreement which is enforceable is in respect of reasonable expenses.
Thank you, Minister. Senator Mullen, how stands Amendment 5?
Amendment 5 is withdrawn.
Withdrawn.
With leave of the House.
Agreed? Agreed. That Section 20 stand part of the bill. Is that agreed? Not agreed. All those in favour say tá. All those against say nil. Section stands. Thank you. Section 21. That Section 1 stands part of the bill. Is that agreed? Section... No? Section 21. All those in favour say tá. All those against say nil. Section 21 stands part of the bill. Section 22, that Section 22 stands part of the bill. Is that agreed? Agreed. Not agreed. All those in favour say tá. All those against say nil. The section stands part of the bill. Section 23, that Section 23 stands part of the bill. Is that agreed? Agreed. Nil. Not agreed. All those in favour say tá. All those against say nil. That Section 23 stands part of the bill. So on to Section 24. The question is that Section 24 stands part of the bill. Is that agreed? Not agreed. All those in favour say tá. All those against say nil. Section 24 stands part of the bill. Section 25, that Section 25 stands part of the bill. Is that agreed? Not agreed. All those in favour say tá. All those against say nil. Section 25 stands part of the bill. Section 26, that Section 26 stands part of the bill. Is that agreed? Not agreed. All those in favour say tá. All those against say nil. Section 26 stands part of the bill. Section 27, that Section 27 stands part of the bill. Is that agreed? Not agreed. All those in favour of Section 27 say tá. All those against say nil. Section 27 stands part of the bill. Section 28, that Section 28 stands part of the bill. Is that agreed? Not agreed. All those in favour say tá. All those against say nil. Section 28 stands part of the bill. Section 29, that Section 29 stands part of the bill. Is that agreed? Not agreed. All those in favour say tá. All those against say nil. Section 29 stands part of the bill. We're on to Section 30. The question is that Section 30 stands part of the bill. Is that agreed? Not agreed. All those in favour say tá. All those against say nil. Section 30 stands part of the bill. That Section 31 stands part of the bill. Is that agreed? Not agreed. All those in favour say tá. All those against say nil. Section 31 stands part of the bill. Section 32, that Section 32 stands part of the bill. Is that agreed? Not agreed. All those in favour say tá. All those against say nil. Section 32 stands part of the bill. Section 33, that Section 33 stands part of the bill. Is that agreed? All those in favour say tá. All those against say nil. Section 33 stands part of the bill. Section 34, that Section 34 stands part of the bill. Is that agreed? Not agreed. All those in favour say tá. All those against say nil. Section 34 stands part of the bill. Section 35, that Section 35 stands part of the bill. Is that agreed? Not agreed. All those in favour say tá. All those against say nil. Section 35 stands part of the bill. Section 36, that Section 36 stands part of the bill. Is that agreed? Not agreed. All those in favour of Section 36 say tá. All those against say nil. Section 36 stands part of the bill. Section 37 in the names of Mullen and Keoghan.
Already discussed.
It's already discussed. Are you moving the amendment, Senators Mullen and Keoghan?
Yeah. Withdrawing with leave of the House.
Is that agreed? That's agreed. So then that Section 37 stands part of the bill. Is that agreed? No. Not agreed. All those in favour say tá. All those against say nil. Section 37 stands part of the bill. Section 38. That Section 38 stands part of the bill. Is that agreed? Not agreed. That all those in favour of Section 38 say tá. All those against say nil. Section 38 stands part of the bill. Section 39, Amendment 7, Sherlock, Hoey, Moynihan and Mall. Senator Sherlock.
Are
you moving?
Yes, I'm moving.
Thank you.
I'm moving. Laska here, I'm conscious that there's many amendments in front of us today, so I intend to only speak once in order that we get through this bill, because I think it is a momentous day that we will see if eventually, finally, this bill passed through, hopefully, this House. I think for many of us who've been waiting so many years now to have a legislative framework in place for assisted human reproduction in this country. I think it's an emotional day, and particularly for those who've been campaigning for a legislative framework for surrogacy, and to pay tribute to everybody who's been involved in that, Senator Siri Carney, and indeed, those who are here in the gallery today, because obviously we've had clinicians operating with a degree of uncertainty in this space over many years, patients operating with a degree of regulatory uncertainty, and I spoke last week about a wild west that has prevailed in some circumstances with some providers and in a for-profit driven sector. Not all providers are for profit, but some are, with the result that there were not sufficient protections in place for those seeking assisted human reproduction treatment in this country. So I'm thinking today of the women, the couples who have gone through the 10,000 plus or minus cycles in this country every year over the last number of years. I'm thinking of all those who could not afford IVF over many years, but will now have their hopes raised, and it's great to see that we have the public scheme. And I suppose it's just important, Minister, just to reiterate that we want to see more people accessing that scheme. We know that the waiting periods are far longer than what they should be. We're told they're about 18 weeks at the moment when they should be 12 weeks. We hear that the waiting times to see a consultant are about 10 months. Now that is frankly not good enough. I appreciate the system is getting up and running, but it needs to do better. And similarly from our party, in the Labour Party, we have talked about that having a publicly funded IVF system is brilliant, but there's a glaring gap there, and that not everybody can equally access that scheme in the absence of having reproductive health leave in the workplace. And I want to pay tribute to the work of Minister O'Gorman in commissioning the Places Research Project, and Professor Keelan O'Donoghue in UCC in looking at early pregnancy loss and the impact in the workplace of that, and to, I suppose, appeal to yourself as Minister for Health that we now have seen it stalled in terms of any commitment to progress, and we want to see the government follow through on what we saw as commitments to legislating for workplace leave for those in particular who experience early pregnancy loss, and what we would strongly believe in the Labour Party, those that are going through fertility treatment, because as we all know, it's not a once-off procedure. It does involve time out of the workplace, and not everybody depending on their work, can do that. So to Amendment 37 and Section 39, well, this relates to the preservation and storage of gamete or reproductive tissue of a child or person under the age of 18 in the event that person under the age of 18 is facing a treatment which will significantly, or to use the words of the amendment, permanently diminish the fertility of the person. And we welcome that provision. But what I cannot understand is why there was provision, and I raised this last week, Minister, in the original bill, and that provision has now been taken out for children who, for those under the age of 18, who are facing premature or infertility arising from a condition that they have. And we know that these are rare conditions. We know that these are a small number of children. But to those children and those families, it is enormous. Children with Turner syndrome, galactosemia, BPES. And for these children, obviously losing their fertility because of their treatment or because of their condition, and the two are separate, it's obviously life-altering. And we strongly believe that provision should be made, that the potential to have children later in life when they are adults should be put in place in this legislation for children for whom infertility is a side effect of the condition that they have. Now, Minister, I'm not a clinician, but I'm a legislator, you're a legislator, we're all legislators here. And when I see provision for one set of children in the bill, those who have to undergo treatment which will impair their fertility, and I don't see provision for another group of children who will experience infertility because of the condition that they have, we have to ask why. And I hear what you have said, that you're going to bring forward amending legislation in September. But I cannot for the life of me understand why we have such a big bill here in front of us now and why you're bringing forward amending legislation in September. You know time is of the essence. We all know here time is of the essence. And I believe there's a very real fear that we may not see that legislation in September. So I'd like to hear precisely what you're going to be bringing forward in September, whether it is primary legislation, whether it's a statutory instrument, or what precisely is going to be done in September. Because I, for one, am very concerned that we're going to have commitments to legislate from today, and that those commitments will never be implemented. I think the other important point I want to make with regards to this amendment is that I'm really conscious that there are people here, people in this gallery today, clinicians who've been working in this area for many, many years. And we as legislators are having to effectively to legislate, to regulate and supervise the processes surrounding assisted human reproduction. And I think while many of us here may understand the inputs and we might understand the outputs, I think there's very few of us in this chamber who actually understand the science and the medicine relating to the actual processes. And so we're very much in the hands of the clinicians, really, in terms of how we shape this bill. And I'm really glad that they have been a very significant part of the conversation in formulating the bill that we have in front of us today. But I do want to raise a concern, though, because when I raised an issue last week that had been articulated to me by paediatricians, by experts in the field of assisted human reproduction, I must say I felt those concerns were dismissed out of hand. And I was taken aback by the manner in which you dealt with those concerns, because there is a distinction between infertility brought about by treatment and infertility brought about by a condition. And I believe that you, Minister, don't recognise that distinction. This bill, as I read it as a legislator, does not recognise that distinction. And I don't say lightly, but I do believe your response last week, in which you questioned the ethics of the clinicians who brought this concern to us, that reflected an arrogance. And, we're all too aware in this House that for many decades that there was an arrogance on the part of legislators when it came to legislating for reproductive and fertility rights in this country. And I would like to think that that arrogance is behind us. I would like to think that that arrogance is beneath any Minister for Health. But unfortunately, it was an arrogance that we saw last week. And I think it was regrettable that you were calling out the ethics of the clinicians who brought those concerns to us, particularly when many of those clinicians have given enormous public service to this state, sitting on the 2005 Commission on Assisted Human Reproduction. And Senator Siri Carney talked about that. It was Minister Micheál Martin who was then Minister for Health. It is that long ago. There are clinicians who've sat at various committees with the Department of Health. There are clinicians who've come and sat at the pre-legislative scrutiny and other committees in this Oireachtas. So they have served our state well. They have acted in the public interest and done everything whenever asked to try and ensure that we would have a comprehensive and best practice set of laws in this country. But back to the substance of the amendment, Minister. Last week you said, and I want to just quote this, "I want to assure everybody that no child will be excluded. If the treating doctors say there is a risk to the child for any reason, whether a progressive condition or a non-progressive condition or a treatment he or she has to go through, that child will be covered." That is the policy position. That may be the policy position, Minister. That may be your position, but I don't read it as the position in the legislation. And if there's anything that the past number of decades have I suppose, informed us, or if there are any lessons to take, it's number one, that yes, we should absolutely trust the doctors. But secondly, we need to provide certainty to those doctors. And I believe there's questions now, and there needs to be legal clarity given to those patients, those children under the age of 18 who are currently undergoing gamete or reproductive tissue storage or preservation. Because if it is not included in this bill, where stands that storage or preservation treatment for those children who have conditions which, unfortunately and very sadly for them, is bringing about the early menopause or is significantly impairing their fertility? So, crucially, Minister, I would like to have that certainty in this bill. I have very real concerns that we'll be back here in September, specifically dealing with the changes that you say you're going to bring. I take in good faith that you are committed to doing so, but time is of the essence, and I don't see why we'd waste an opportunity now to not introduce them. Garmagut.
Mr. Minister.
Margaret Cahirlock, can I start by acknowledging the Senators and Labour support for this bill? I think it is very welcome. I think descending into name-calling is unfortunate. I think personalising it in that way is deeply unfortunate. I disagree entirely with how you've just characterised the discussion you and I are having. I know when I was in opposition for years and years, I tried to convince sitting ministers to amend legislation in ways that were important to me. It very rarely happened. Very, very rarely. I could count on one hand the amount of times it happened. I committed to you right here 7 days ago that I would amend the legislation based on what you had brought forward. And describing that interaction and my commitment to you and my commitment to these children as arrogance, I just don't understand that. I don't understand it. When it comes to the ethics, what I specifically questioned was a letter to parents which sounded incorrect to me. It's technically incorrect, legally incorrect, and I have no doubt will have caused great distress to those parents. Then you can go back and you can read the blacks as to what was said. That really worried me, that any clinician would write a letter like that to parents. I don't think the letter should have been written, and I do question it. I certainly don't question anybody's bona fides, be they in private practice or in the HSC, in terms of trying to come to the best possible answer. Ultimately, this bill will be regulating private practice. It will be regulating work within the HSC. And as I laid out to the Shannon last week, the reason we changed it was because we got a very strong representation from the experts in the HSC. That's why. But when you laid forward the counter-argument, and indeed I had consulted before coming into second stage on that basis, I agreed to incorporate your amendments. So I don't understand why you would come in a week later and be sort of having the same debate. Like I heard you, I listened very carefully. We prepared for second stage last week on the basis of your submission. I sought additional clinical advice. I got it, and I committed to you that I was going to change the bill. Like, that's what happened last week. So I just don't understand the representation that you're putting forward today. We're working together on this. We're changing the bill based on your representations. You read out my commitment, which was we're going to include both. We're going to include conditions and we're going to include treatment. I think in this case the HSE got it half right, and so we're going to add in the other half. So the reason we're not doing it now is because there is a danger that the entire bill wouldn't get through all stages of the Oireachtas in the next 3 weeks, and that's something that I'm not willing to allow happen. So in my wrap up, I'll go through, Chair, the list of policy issues which we're going to be amending in the bill. So I'm sorry, Senator, I thought you'd be reasonably happy with last week. You brought something forward, I've agreed to amend the bill. I just don't understand your contribution today. I'm puzzled by it.
Senator
Thanks, Minister, for that response. I suppose in the first instance, I'm a much more inexperienced legislator than you are, but I suppose in my past 4.5 years here, I've seen government amendments to their own bills, and we see this on a regular basis, and we all faced a deadline here of last Monday for amendments to this bill, and it was absolutely open to yourself to bring forward an amendment to your own bill. So why didn't you do it this week as opposed to having to set up a whole new process in September? That does not make sense to me. And the second thing I just wanted to say, with regards to when I used the word arrogance, and I was very carefully using that word arrogance, and I felt you were disingenuous in how you characterised what I said, because I used arrogance in the context of you questioning the ethics of the clinicians who raised concerns with us. And I would like to have thought that if a Minister of Health hears that Senator TD is raising the concerns of a clinician, that at least they would be listened to, as opposed to being dismissed out of hand, and that their ethics would be questioned. And that's at the heart of why I believe there was an arrogance in your reply. So I will respectfully await the legislation in September, and I'll be here to support it and say thaw all the way. But it makes no sense to me that the department have sat on their hands for the past week and have not brought forward an amendment to do what you say you're going to do.
Sorry, Minister. Senator Mullen.
I would like a bit of clarity on this too, because I'm just on that latter point, because I heard what Senator Sherlock said last week, and I did hear your response, and I did actually wonder why you used the word unethical. And I was wondering, were there some facts that were at your disposal that you weren't sharing with us? Because I could understand why you would say that the letter from these clinicians was wrong, it was incorrect. But when you say something is unethical, you're making a fairly serious moral charge. Now, you didn't, it wasn't clear to me who you were talking about, but was it just an imprecision in your language, Minister? Or is it that you regarded it as unethical to write something that was mistaken, that they should know better and do their homework before they write something that you're now saying is mistaken? Or was there something else that you knew of, or did you think that they had some vested interest in leading people astray? Because it's very unusual to hear the use of a term like unethical when when all the information you were supplying us with was that whatever was written in a letter or letters was wrong. There's lots of why people put stuff that's wrong into letters or give inaccurate information without necessarily being unethical. So what was your intent in saying that it was unethical?
Minister.
Thanks very much. And to Deputy Sherlock, it's not possible typically to turn around a government amendment that quickly. I spent many years in opposition. I've tabled God knows how many amendments. And the opposition amendments don't have to go through the same legal rigour, as we all know. So there's a process in place whereby we have to have drafters, we have to take legal advice in the department, it has to go to the AG's office. Given that this is a clinical issue, we'd need to have pulled back in the HSE clinicians, And so in that time period, it would have put the whole bill at risk. And to the Senator's point, no, I'm not going at, there's no additional information. I'm going purely on what Senator Sherlock read out. I think writing to parents around technical amendments to a bill and saying this is going to mean that your child can never conceive in the future, I think that's a pretty extraordinary thing to do. But that's just my opinion. Maybe it was simply technically incorrect. I don't know. But you and I have been around here a long time. People do various things to influence legislation, as we know. And I certainly didn't like the nature. The nature of that did not sit well with me. That was it.
Okay.
Senator Sherlock and then Senator
Mullen.
Sorry. Senator Sherlock.
Minister, I've purposely not tried to personalise this now, and I haven't mentioned names today, but I think it is worth, just for the record here, just lest there's any doubt, right? There was a letter received, there's been many emails received by yourself, okay, from clinicians with concerns about the issues that I have raised. And just to say that there was an email received addressed to yourself at the start of this week, and it came from 3 clinicians, Dr. John Waterstone, who's a consultant gynaecologist and medical director of the Waterstone Clinic, Dr. Mary Wingfield, former consultant National Maternity Hospital and former clinical director of the Marion Fertility Clinic, and Dr. John Kennedy, medical director of Therapy Fertility. Now, 3 very well-known experts in the field of assisted human reproduction, 3 clinicians who have many, many decades of experience behind them. And they talk about the need for this bill, and they're hugely supportive of this bill, and they want this bill to go through. But they just make the point, right, because when you talk about your experts in the Department of Health, they make the point that, well, they use the word the HSE, but I take it that they mean the Department of Health, right, from whom, in contrast, the HSE, from whom you take advice, while it has many excellent doctors and staff, has historically no experience in the provision of AHR services and has never, to our knowledge, contacted any AHR specialist regarding the medically complex aspects of this bill. So, just to put on the record that these are 3 of the leading AHR experts in this country, and they obviously speak to many of the other experts in this country in that field, and they feel they were not properly consulted with regards to the medically complex aspects of this bill. Now, I understand that the Department of Health has their own set of clinicians to consult, and the HSE has other clinicians to consult. But I suppose ultimately, if we're looking at talking to the people who are the leaders in this particular field, you know, they have put, you know, in a private letter to you, but a part of which I have read now on the record today, because it's just really important when you use the word personalising that we just be clear as to what the facts are. Gurmagat.
Senator Mullen.
Yeah, well, as I say, I find it's in a way ironic because I suspect that some of the procedures that they're involved in I would regard as unethical, but nonetheless I would defend their right not to be accused of being unethical if they communicate certain beliefs about the state of things that they believe to be true in good faith. So I can only conclude, if we're talking about the same letter, are we, Senator Sherlock? I can only conclude, Minister, that you regard those people as having acted unethically in communicating the way they communicated. So you're either saying that they said something that they knew not to be true, or that they were reckless in saying something which, had they checked, they had in other words, that they had constructive knowledge, that they were reckless in saying something that, had they checked their facts, was not true. And I do find it interesting that you know, it's one thing to say, you obviously wanted to go beyond saying that they were mistaken, and you wanted to in some way suggest or impugn or at least put it out there that they might be acting dishonourably. It's quite a serious thing to say about people. I mean, obviously you did so under privilege, but if I were a clinician and I put something in a letter that I believe to be true, I wouldn't be happy with the Minister for Health going around saying that I had acted unethically or even suggesting that I had acted unethically.
One more time to Senator Sherlock. What you stated is simply false. What you've just stated is that some of the people you've referenced, and I haven't used any names in here, but some of the people you've referenced were not consulted. I can tell you categorically there was extensive consultation with at least one of the people that you've referenced. Extensive consultation. So, unfortunately, it just is not true that there was no consultation with the experts in the private sector. There was extensive, technical, ongoing consultation over a great many of these issues.
Sherlock, okay. Okay, so the question is, are you moving Amendment 7, pressing?
Moving and pressing.
Pressing. The question is that Amendment 7 be part of the bill. Be made. Is that agreed?
Agreed.
Those in favour say ta.
Ta.
Those against say nil. The question is defeated. Thank you. The question is that Section 39 stand as part of the bill. Is that agreed? Not agreed. Not agreed. Those in favour say ta. Those against say nil. Section 39 stands part of the bill. Is carried. The question is that Section 40 stand part of the bill. Is that agreed? Not agreed. All those in favour say ta. All those against say nil. Section 40 stands part of the bill. Section 41. The question is, the Section 41 stand part of the bill. Is that agreed? Not agreed. Those in favour say ta. Those against say nil. Section 41 stands part of the bill. Section 42. The question is, the Section 42 stand part of the bill. Is that agreed? Not agreed. Those in favour say ta. Those against say nil. Section 40, the question is carried. Section 42 stands part of the bill. Section 43, Amendment 8, it's already discussed with 5. How stands? Is it being moved?
Moving it and withdrawing it with the leave of the House.
Is that agreed? Agreed. The question is that Section 43 stand part of the bill. Is that agreed? Not agreed. Those in favour say ta. Those against say nil. Questions carried. 43 stands part of the bill. Section 44. That Section 44 stands part of the bill. Is that agreed? Not agreed. Those in favour say ta. Those against say nil. Question carried. Section 44 stands part of the bill. Section 45. The question is, Section 45 stand part of the bill. Is that agreed? Not agreed. Those in favour say ta. Those against say nil. Question carried. Section 45 stands part of the bill. Section 46. The question is, Section 46 stands part of the bill. Is that agreed? Not agreed. Those in favour say ta. Those against say nil. Question carried. Section 46 stands part of the bill. Section 47. The question is that Section 47 stands part of the bill. Is that agreed? Not agreed. Those in favour say ta. Those against say nil. Question carried. Section 47 stands part of the bill. Section 48. The question is that Section 48 stands part of the bill. Is that agreed? Not agreed. Those in favour say ta. Those against say nil. Question carried. Section 48 stands part of the bill. Section 49. The question is that Section 49 stands part of the bill. Is that agreed? Not agreed. Those in favour say ta. Those against say nil. Question carried. Section 49 stands part of the bill. Section 50. The question is that Section 50 stands part of the bill. Is that agreed? Not agreed. Those in favour say ta. Those against say nil. Question carried. Section 50 stands part of the bill. Section 51.
Yeah. Section 51, because I imagine there'll be a bit of debate. Could we break for 5 minutes?
If the acting leader. Right. Acting leader.
I
suspension for 5 minutes.
Suspend for 5 minutes.
Is that agreed? Agreed. Thank you.
51, Amendments 9 in the name of Senators Mullen, Keoghan, 9, 16, 27, 29, 49 and 53 are related and may be discussed together by agreement. Senator Mullen, are you moving the amendment?
I think Senator Keoghan is going to move.
Senator Keoghan is.
51. Right, okay. Yes.
Will you move the amendment,
yes,
please?
I move the amendment.
Amendment 9, please.
Sorry?
Amendment 9.
To Amendment 9.
Thank you.
Yes. Okay. Substituting 5 years for 2 years. So I suppose really we want to do this because in light of the recent influx of the war in Ukraine, and Ukraine is probably the largest market at this moment in time when it comes to surrogacy in the world. And so that is why really we've asked for this to be extended to 5 years. And during the committee stage, I obviously wanted to bring a number of witnesses that didn't get to be possible for a number of reasons, but one of those was Mykola Kubele, and he was the Ukrainian's commissioner of the President of Ukraine on the rights of the child. And basically, he had huge concerns in relation to commercial surrogacy. And some of the quotes that I took from the document, basically, he stated that Ukraine had become a supermarket for surrogacy. The child is already becoming a commodity, but a woman is an incubator and has to carry this product for someone. Now, these are words that he used. If during a pregnancy the client decides that they no longer want the child, the surrogate must have an abortion. If she doesn't, all the funds must be returned. If she gives birth to the child and customers don't want to take it away, she has to give the child to an orphanage because she has no rights to it. Now, these were the words that this child commissioner in Ukraine used in relation to surrogacy. And my concern is, because obviously a lot of the people that have come from Ukraine over the last couple of years, many of them would have been women. And I would like to extend this piece of legislation to 5 years rather than 2. Thank you.
Thank you, Senator. Senator Mullen, have you indicated?
I would just add a few words if I may.
Yeah, sure.
Absolutely. And welcome back. Yeah, well, look, I just want to emphasise our support what Senator Keoghan says. It seems to me to be, within again, stress, it's something that I'm concerned about, these provisions that are happening at all, that we're providing for at all. Obviously, domestic surrogacy of whether to be no commercial nexus is easier to at least try and ensure that, though debatable whether one can fully ensure that there's no commercial nexus, certainly much harder in the context of international surrogacy. But it does seem to me to be a precaution, among other desirable precautions, that the person who enters into a surrogacy agreement has been habitually and lawfully resident in the state for less than 2 years. Senator Siri Carney spoke about, the agency of women who allow themselves to be drawn into providing surrogacy services, and that it seems to me that this is the best weak defence against the argument that surrogacy exploits the poor. Surrogacy undeniably exploits the poor. As I said earlier, you don't see rich women carrying babies for poor women. Maybe in the most exceptional of circumstances where a rich woman would see herself as doing so altruistically. I wonder whether such a person exists. But when one considers what's involved in getting pregnant and then the eventual loss of a child that you've nurtured in your womb for 9 months, it seems to me that no woman would willingly choose to do so. I understand, and we heard from Senator McDougall about a situation where a person carried a baby because her sibling was unable to have a child. So I suppose there's always exceptions, but the reality of surrogacy is that it is the exploitation of the poor by the rich, and to suggest that a woman who provides surrogacy services and puts herself through all of that and all the emotional downstream consequences then of being sundered from the child that she has nurtured and brought to birth, and indeed the health risks that can be associated with carrying a child who is not genetically your own. All of those issues are in play here. But as I say, Senator Siri Carney seeks, sincerely but wrongly, to talk up the agency of women who provide surrogacy services. And for the same reason, I don't know if Senator Siri Carney was in these houses when we eventually criminalised the purchaser of sexual services. But the same arguments were made over the years, and I was one of the first in these houses, going back to when I was first elected in 2007, and informed by the excellent work being done by Ruhama and other organisations to say, that nobody really freely consents to sell themselves in prostitution, because invariably there are situations of abuse, of financial disadvantage, sometimes of drug addiction, that the person in that situation is in a truly pathetic situation. And therefore to say that they're somehow just freely contractual, of course there are people who advocate for just a contractual and transactional approach to this and say a person is entitled to sell their body. But we don't allow that as a matter of public policy in this country anymore. And one of the reasons is that we don't truly recognise that there can be free agency as a matter of public policy. There can't be free agency to sell yourself in that way. And therefore it's in no denial of your right to contract, or your normal right to engage in free contracts, to say any more than one could say that there could never be, a right to freely sell your own body parts, and we all know what we would think of it. Again, these issues are terribly complex. We extol those who freely and voluntarily donate an organ for the sake of another human being, but we condemn and deplore and criminalise any possible financial connection in that regard. And it seems to me that the surrogacy situation is exactly in parallel with it, Minister, because here you have a person selling something of themselves, selling their nurturing power, selling their nurturing self, something that a person should never be asked to sell. And of course, I know you'll respond that this is not commercial, etc., but as we will show and have shown, it is inevitably and unavoidably commercial, particularly once we get to the international surrogacy situation. So this lack of freedom, de facto lack of freedom, even if not de jure, that is built into the surrogacy contract, now, is the reason for this proposed amendment. Because when you think about it, we already know that people who come to this country are desperately poor and desperately disadvantaged. There can be language and all sorts of other barriers in the way of their flourishing. They are more easily prone to exploitation. We know all about women who are trafficked into the country and so on, and what they suffer and undergo. And indeed we can say that not nearly enough is being done by the state or by the organs of the state to combat human trafficking, and that's why we fare so badly in the US trafficking in persons report so frequently. And so when it comes then to the idea that a person might enter into a surrogacy arrangement as a surrogate mother, only having been habitually and lawfully resident in the state for not less than 2 years. I'm not suggesting that people will be procuring illegal entrance into the state for the purposes of surrogacy arrangements. Clearly, we're talking in this amendment about a person having to be habitually and lawfully resident in the state. But in the very unusual circumstances and the tragic circumstances that we have found ourselves in this country, there are people who are habitually and lawfully resident in the state for a relatively short period of time, and for at least 2 years at this point, who remain profoundly vulnerable, and where there is a far greater risk of inducement being involved in some way. And it's also the case, of course, that some of these people are very young, and therefore, you know, by substituting 5 years for 2 years, we would be at least seeking to ensure that they wouldn't be quite so young than they would otherwise be when they enter into this contract that is undoubtedly harmful to them over the longer term.
On Senator Carney, no, on Tara.
Can I thank the senators for submitting the first 4 amendments in this grouping. With regard to Amendment 9, which proposes to increase the length of time that a prospective surrogate mother in a domestic arrangement has to have been resident in the state from 2 years to 5 years, this residency requirement of 2 years was included to act as a safeguard against trafficking and to allow the demonstration of some form of lasting connection with the country. I consider that we have struck the correct balance in setting the period at 2 years, and that 5 years may be viewed as an excessively long period of time. However, there is no right answer to this. It is a matter of informed judgment on all our parts. And it is, I think, the kind of issue which can be and will be looked at as part of the review of the legislation, which is part of the bill itself. Amendment 27 similarly proposes the same situation for international surrogacy, and the same points are made. Amendments 16 and 29 seek to increase the minimum age from 21 to 25 for an intending parent to apply for approval for a proposed surrogacy arrangement, be that a domestic or international surrogacy. The minimum age for the provision of AHR treatment generally is 18 years of age. The age limit for surrogacy was set at 21 to reflect the specific additional complexity and difficult issues which arise from undertaking a surrogacy agreement. The extra life experience, maturity, which a person at 21 would generally have, are important factors here, as well as potentially giving enough time for intending parents to be able to demonstrate that they require surrogacy to start a family, for instance.
Senator Mullen? Oh, sorry, Senator Mullen, yeah. Senator Mullen, yes.
Yeah. Well, now, just one thing. I noticed that these amendments are grouped, and I'm not entirely happy with that. Can I ask for...
Sorry. Go ahead.
I would like to be able to speak to some of these amendments more sequentially. Is there any way that can be facilitated at this point, or is that grouping?
The groupings have already been agreed.
Sorry?
This particular grouping has been...
The groupings have been agreed. They're not done, as you know, to prevent members speaking.
No, I understand that, but
it's 9, 16, 27, 29, 49 and 53 are related, and can be discussed together.
Yeah, it's just that I don't necessarily want to discuss them in that order, is what I'm saying.
But you can. What's your difficulty? Sorry, now. What's your difficulty?
My difficulty is that I would rather. There are some of those that I think I might rather speak to at the point where I'm moving them.
No, that's not. The norm, as you know, is that we speak. We group the amendments that we. They're related amendments. I'm not trying to be obstructions to you.
No, I understand that. I'm just saying that. I'm just going to have to go through my notes here in a different way. But I'll do my best. Yeah, that's fine.
That is the precedent, as you know, as a long-standing member of the House.
I'm not crying foul.
But you can, but you're wrong if you do. And anyway, go ahead.
Well, don't contradict me before I make the assertion, please. No, but I'm just saying that. When were these agreed, by the way? Was that an order of business, or we?
The groupings were circulated. Were probably circulated either last night or this morning.
Yeah.
And members will be aware of them before they come into the chamber.
Would they have been agreed on the order of business?
And they're agreed at the start of each individual. So when I moved Amendment 9...
Yeah, I probably just didn't hear you. I
read the groupings out.
I should have squawked at that point, and maybe I'd have got to hear it.
You should have.
Yeah, that's fine. I'll try and squawk in future. But anyway, see how for all the good it might do. Okay, that's fine. Well, let's start then with just on.
Just so in case you or others think that I'm trying to be unfair to you, I'm not. But just so you understand, if you decide, at other junctures of the bill that the groupings are not what you like, and you may want to speak to a particular amendment at that time, if there's consensus in the House, and if I'm in the chair, I'll certainly allow you to put.
I understand, and thank you for that. Now, so okay, well, let's just start with Amendment 9. Sorry, I've already spoken to Amendment 9, but I just would say, you know, there are real concerns in relation to human trafficking in connection with surrogacy. It's bad enough that surrogacy will exist on the passing of this legislation, but practices that we'd all regard as slavery is something we should avoid entirely. I note what the Minister says, that he's striking a balance, and he adverts to the review after 3 years. But I would put it to him that surely you could also review bringing it back to 2 years. You know, you could take the more precautionary step at this point and at this juncture, and at the 3-year review stage, one could argue it in the other direction. Then you can say, well, does it still need to be 5 years? Because, you know, as you said yourself, you're entering into unknown territory with this legislation. You've curated a piece of legislation that is without precedent. And I would have thought that the precautionary principle would say that you would go with this and say, let it, and particularly given what's happening in the country in recent years, because it is easy to imagine someone bringing over a relatively or a newly arrived migrant, and that person then being exploited for the purpose of surrogacy. I think that people who engage in surrogacy services should at a minimum be able to demonstrate that they have a certain level of permanency in our state, and 2 years is nothing, as we all know. The last 2 years and the time since the start of the Ukrainian war has absolutely flown, and I would say failure, you know, to accept the precaution you know, that's on offer here in our amendment really risks the intent of your own precautionary position as adopted in the legislation, you know, being moot. So I would urge you to rethink that one, Minister. Now I have to try and get to amendment. It's amendment number 16. Now, in page 61, line 30, deleting 21 years. Okay. Well, again, clearly this is self-explanatory in that it is again about protecting the person and providing in page 61, line 30, that any intending parent shall have attained the age of 21 years, and we're proposing that this is increased to 25 years. The idea of a very young adult taking the extraordinary life step of bringing a child into the world and doing so with the support and the agency of the state, and doing so in a manner that entails in all likelihood the use of a donated sperm or egg, and indeed in this case that entails the use of a surrogate woman as a surrogate mother. You know, we could have an endless debate about what is the appropriate age to start permitting certain things. The age of consent in sexual matters, the age at which one may take alcohol, the age at which one may vote. There is it is coming into vogue in some quarters to suggest that children as young as 16 be enabled to vote. Personally, I take the view that very often this is not an evidenced, that those who propose the lowering of ages of consent or permissibility seem to fail to take into account the science around people's development, you know. Like, for example, why do insurance companies charge young men so much in order to get insurance to drive their cars, you know? And we all know why. It's a statistically based decision. Might not always seem just to those young men that insurance companies do what they do, or perhaps young women as well. But it's all down to do with what we know about the maturity or otherwise of young people, even into their 20s. you know. And we hear people talking about the frontal lobe and its development and so on and so forth. So it seems to me, while I'd be slow to say that we should put the voting age back up from 18 to 21, it's certainly as logical to propose that as it is to propose the lowering of it to 16 years of age. And in the same way, I think, you know, we shouldn't be afraid to say that the bringing of a child into the world, while it might happen, you know, when people do what comes naturally at a much younger age, again, the idea that you would allow the procuring of a child through surrogacy and through contract in this way, and that it could be done by a person as young as 21, seems to me to be just one of the many problematic aspects of the bill. So I would urge. I might just ask you, Minister, would you mind just detailing for us again the reason why you're not, before I continue, why you're not accepting that particular amendment?
Senator Siri Karen. Okay.
Yeah, if you'd like to answer those, because I have 2 amendments in this group.
Yeah. Thanks very much for that, Senator. Yeah, so as stated, AHR treatment generally is available at 18. The age limit at surrogacy was set at 21 to reflect the additional complexities and issues which can arise, and indeed be cognizant of the fact that there would be enough time given for intending parents to be able to demonstrate that they require surrogacy to start a family. The proposal is to move it to 25. I don't believe that's necessary. And whilst the Senator references the very significant decision people take to start a family, obviously people take that decision at many ages, and often below 25, below 21, sometimes below 18. As well, obviously. So I believe 21 strikes the appropriate balance.
Senator Siri Carney.
Thank you very much, Cathaoirleach. Minister. I have 2 amendments in this group. I won't be moving any more amendments, but they're merely there for discussion purposes, as I had flagged to your officials would be the case. But before I get into them, I just want to address a couple of things. There were a few chestnuts that were always predictable, so let's just nail those here and now. The first is the quotation from the Ukrainian ombudsman or special rapporteur. I just want to clarify that there was an attempt to contact that person to bring them into the surrogacy committee, so it's not true that he was totally rejected. There was an attempt, but we were at the height of the war at that stage, at the early weeks of the war, when everything was difficult in Ukraine, and we were expecting people arriving in Ireland without any documentation or anything like that at all. So there was an attempt to locate that individual, invite him into the committee, and that didn't happen. So I just want to correct that error. But also, he's very handy to be deployed to use vulgar language around our children and our families. And his vulgarity should actually not be repeated by any parliamentarian anywhere. He was being dramatic for the sake of being absolutely and utterly vulgar in the description of families, and that anybody would come in here and have the audacity to use the word market is really quite appalling. So let's just park that. The next one is this thing of describing surrogate mothers as people who allow themselves, the terminology, allow themselves. Then to do a correlation or say, this is similar to the argument, when we were talking about prostitution. Seriously, absolutely seriously. We're in a philosophical space where it's okay to actually control women, to presume everything about how they make decisions around their own bodies, to presume that they're all poor, which they aren't, to make all of those assumptions is really quite outrageous. It besmirches the women who and their own dignity and autonomy and agency. And while I know it suits a certain agenda to cast everything in that light and say, well, I don't really know what I'm talking about and I'm wrong, actually I do. Actually, I do. Actually, I've been in this space for a long time. I've seen the research. I've gone and spoken to practitioners. We had experts from Cambridge University who came into the committee. Actually, I do. Not the one or two exploited women who come onto webinars and talk about their lives and how dreadful they were and the dreadful decisions that they made and that people around them made. Not just those examples, but actually of the load of other examples that are going on here. So the idea that the women who are surrogates, that they are besmirched in any way as being people without agency and people totally exploited, that any of that occurred. In fact, we had one of them in the gallery last week. I'm glad she's not here today, because I'm quite sure she would have come over the screen in sheer annoyance. So that idea is absolutely outrageous. It is an outrageous characterization of women through surrogacy and those women in all of our lives and the role that they have played in our lives. And it undermines also the care that they were all given by parents throughout their pregnancies. So I want to reject that. As regards the first the clarification or the requirement to bring down the years of residency to 2 years as to 5. What happens if you have a sister who's been living in Australia and comes back? There's all sorts of things that would catch if that amendment were to be accepted. That just wouldn't work. And furthermore, the idea of free movement. I get the 2 years. 2 years is sensible. I also would be cautious to characterise all of the women in Ireland who have come from Ukraine as being particularly vulnerable. Many of them are fantastic contributors to our society, to our hospitals, to our communities, and in roles of great responsibility. Minister, I have 2 amendments in under this group, and it arises out of an issue that you know may be a problem. I first talked about this morning the Commission report in 2005. The Commission report talked about that because surrogacy was reality in Ireland in 2005. And so we have children that are that old. You have a provision in the bill that actually the application for parental orders is one that may be made by an adult child, or maybe the child might be the adult child might actually be an applicant. And why would they want to do that? And why is guardianship insufficient? Well, it's insufficient because it doesn't create a lifelong legal relationship. It doesn't do that. It doesn't. All of the things that flow from a parental order are things even like inheritance. All of those things, decision making around parents and children. All of those things flow from parental order and parental status between children and their parents. So it would appear. But I appreciate, I've had this clarification and I appreciate all the work that's being done, but for the benefit of the people over here who are having heart attacks worrying about it and the people that they support and speak about, there is a request within the definition. To be fair, it's not, Colin has corrected me that it's not in the proofs required for court, but in the definition of a surrogacy agreement, be that a domestic or an international, it says a surrogate is somebody who has been, and there's a couple of different versions of it, but essentially there is a requirement that has to be somebody who was habitually and lawfully resident for a period of 12 months. And the problem is, if you're a child who was born via surrogacy in 2005, what are your chances of being able to prove that? It may be that you're in contact with the surrogate, but it may not be that we have proofs of then. She may have moved country. There are other situations. There is a war in Ukraine. A lot of Irish children were born in Ukraine. There may not be documentation to prove where they were in that state for that period of time. And even in Ireland, there may be difficulties where people moved, or maybe that a sister was here for less than that period of time, or a friend who came home from abroad. So at the time of the surrogacy, they didn't know this was going to be a requirement, so they may not be able to comply with it. And so I consider it to be deeply unfair, if not bordering on unconstitutional, to have to retrospectively apply something that may not be able to be satisfied. And in circumstances where we do permit the possibility that surrogates may not be contactable, may not be found, they may have moved from the addresses that people have for them, if there was documentation, those families that are relying on the waiver of consent in those circumstances where she can't be located, they will be caught in that of being unable to prove that. So there needs to be a discretion, and that is what is behind that residency requirement is causing a lot of anxiety, because there is a fear for very legitimate reasons that might not be able to be satisfied. So in those instances, I've been very careful, and as I say, I'm not asking you to accept my amendment, but I worded it to reflect the integrity of parents in this space. You know, that there will be exceptional circumstances. There will be, you know, in past domestic and international surrogacy arrangements, there will be exceptional circumstances where the court, where that requirement needs to be set aside out of sheer practicality. And that's it. Thank you.
Thank you. No, and Tara,
Gurmageth Cahirlock, and I'd like to speak to Senator Siri Carney's two amendments, 49 and 53. And I just want to reiterate the position as laid out in second stage here last week, which is that it is the current policy intent of the bill that a court, a judge, does have the discretion to waive the requirement around residency for retrospective applications. Now, for future applications, that is not the case. For future applications, obviously, for the pre-order, that has to be established, right? So, specifically for retrospective, one could ask, why have it at all? Because we have a very strong best interest of the child test. Why put it in there? Really, the reason it was put in at all was to guard against things happening since the heads of the bill were known. So, for example, the second stage Dáil session on this was in March 2022, and we knew this was going to take time. And we didn't want a situation whereby people might say, well, up until the bill is commenced, we probably have a few years here where we can avail of this retrospective. We needed to put some safeguards in place for the surrogates, and really that's what it's about. It's not really about surrogacies that happened pre-2022, right, when the detail and the approach was well known. And so there will inevitably be cases where the surrogate can't be found, or where documentary evidence can't be found, or the surrogate isn't willing to provide an affidavit, or, as you say, a sister might have come back from Australia to be a surrogate but may not have been resident in Ireland for the full 12 months beforehand. As the bill currently stands, the clear legal advice I have is that the judge already has that discretion. That's the first point I want to make. The second point I want to make is that discretion is absolutely the government's policy intent. So anyone who might be interpreting this within the court services, for example, applications in the future, I want us to be very clear. The unambiguous intent is that the courts have that discretion. It is not an absolute requirement for retrospective applications. And the third point I want to make is, even with those two things, so that there can be no question of it being misinterpreted in the future, because I know this has been raised as a real concern for some parents who will be applying to the courts. The third and final safeguard we'll be taking is to amend this legislation through the amending bill, which I hope to have ready as soon as the Dáil reconvenes in September. That we will make it explicit, and I don't know if we'll use exactly your wording, but it will be something like that to make what is implicit explicit. Thank you.
Margaret. Senator Mullen, did you indicate?
Yeah. Thank you. Well, again, I just noticed, and it was very obvious last year, that the Minister is entirely in facilitatory mode, and it really doesn't matter what human rights abuses are entailed here. The adults shall have what they want. What I want to add in the context of amendment number 27, which obviously is the international surrogacy version of the amendments to which I already spoke. And I am proposing in page 77 the deletions of lines 4 to 6. Again, requiring and providing that a surrogate mother who is an EU citizen and who has been habitually and lawfully resident in that jurisdiction for not less than 5 years, immediately preceding her entering into the agreement. This is not just a matter of changing it from 2 years to 5 years in terms of habitual and lawful residency, but also requiring that the surrogate mother be an EU citizen. Obviously, I am trying to limit the worst effects of what the government and its supporters contemplate doing here. Like the old man in Connemara supposedly asked by some tourists for the directions to Dublin, I'd be saying, to be honest, I wouldn't be starting from here at all. But since this is what the Minister is proposing, I challenge him to at least accept this amendment, because one other downstream version of what the government proposes to do here is the risk of the development of a surrogacy industry, with foreign surrogates coming to Ireland, being brought to Ireland to avail of the medical system here. So, Minister, I would like you to tell me why you don't accept the proposed limitation of this to surrogate mothers who are EU citizens in the context of your answer. I imagine that your reason for not accepting the 2 years to 5 years change is similar to the one you gave earlier in the context of the amendment on domestic. But why will you not accept the requirement that the surrogate mother be an EU citizen?
I don't see any reason why we would.
Margaret?
I've just put it to you that there is. Thank you. I've just put it to you that there's a risk of a development of a surrogacy industry. We know what the international context here. We heard what the Ukrainian Senator Siri Carney likes not the language, but the question is what's being said true? That's more important than courtesy. You know, there are human rights at stake here. There are people being violated and exploited here. I know Senator Carney and the Minister don't accept that, but that is the experience that cannot be denied. And it's no argument to say that the only people, and I had a Zoom or a Teams conference yesterday in which we heard from people who have been hurt by surrogacy. A woman who made herself available for an altruistic surrogacy situation and who suffered in a way that she had not foreseen as a result of doing it. And there are many, many silent victims of this. And we also heard from a young woman who was brought to life through surrogacy. And I'm sure she's very happy to be alive, but she disagrees with what's going on here and the way that it impacts on people. You know, and I think it's wrong, you know, to dismiss them as the shrieking minority, so to speak. Not Senator Siri Carney's words, of course. It's a form of denialism, you know. There is international concern about this. You know, international, like this is novel. Greece is the only country that allows this. You know? And what we're proposing to say here is that if you must embrace the aspirations of people who want to bring children in the world through surrogacy, at least do your best to stop an industry developing with, as I said, foreign surrogates coming to Ireland to avail of the medical system. So it's too glib, Minister, quite frankly, to say that you see no reason why you should. We know you're not for turning. We know you're captured. But you should at least try and give some kind of credible reason why, in the face of the mass exploitation of people on our continent and worldwide, in the face of the ferment and the displacement brought about by the invasion of Ukraine, and so many other factors that mean that there are financially and otherwise vulnerable people who might be brought to the jurisdiction for this. So I put it to you that it's not enough to say you see no reason why. This is a problematic reality that involves the exploitation of the poor. At least if there is a requirement. And by the way, you know, if all of this is so good, why isn't it possible just to get this done in Ireland using Irish citizens? Or to get it done in the EU using EU citizens? Why is it that you have to enable international surrogacy? And the reason is because there aren't enough poor people to exploit in Ireland and the EU. That's what's at work here.
Sorry.
That's what's at work here.
Just one second, Gamal. Could I ask members in the gallery, please, just to refrain from engagement? Unfortunately, you can't.
With due respect, there are particular.
There are rules in the House that we have to follow.
Yes, there are. Yes, there are. But provocative statements.
I'll bring you in to reply. I'll bring you in to reply.
Yeah, but with due respect, Chair.
I understand.
I don't think that the gallery should be corrected on that.
Well, the gallery can't make comments.
Yeah, but they're not.
I appreciate what you're
seriously.
No. Thank you, Margaret. I would remind all people to be careful with the language we use, please.
We're not in the Stella Cinema, you know, in Rathmines, where people get to react to what they see on the screen. We're talking about human rights abuses.
We are in Shannon speaking about the people of the Republic of Ireland.
That's not a point of order.
That doesn't mean, I don't care.
No, but you do.
It needs to be said.
I accept that.
How dare he be so trite and so offensive and be permitted to be so?
Thank you. Could I remind members in the House, please? And I appreciate it's a very sensitive matter we're dealing with. But the use of language by everybody is important.
It is.
And that includes all of us.
It is.
And I would ask members to be cognizant that we're talking about the use of language and we're talking about people here who have feelings, and I would remind us all to please be sensitive to what we're saying and how we say it.
Yes, and we have to be sensitive to the women, the poor women of this world who are being completely forgotten by this legislation, who are exploited for their bodies, the trafficking that is going on, the trading in children, the commodification of children, the denial up front and in advance and forever of a child's right to be loved and nurtured by their birth mother who has cared for them for 9 months in the womb. The denial of the right of a child to be loved and to have their genetic parents responsible for them. I'm not standing up here for the good of my health. I'm standing up here because I am protesting against the human rights abuses that this legislation entails. So I'm sorry that as much as I respect and value my colleagues in the Seanad, and as much as I sympathise with those who have not been able to have children and have or want to use surrogacy in order to do so, I am protesting that it is an abuse of human rights. And I am saying, and I have to reiterate, that the reason that international surrogacy is on the agenda here is there are not enough poor women that can be accessed to do this in Ireland or in the EU. That is the only reason. And that is why I say because there are not enough poor people to exploit. It isn't that people want, in the first instance, to exploit the poor when they seek a child through surrogacy. It is that they are willing to accept as a consequence of what they're doing in order to alleviate their situation, that they are willing to contemplate a process that is intrinsically exploitative of the poor. And because, as I said earlier, and it was no less insensitive to say, that you don't see rich women carrying babies for poor women. You only see poor women carrying babies for rich women. That is why countless feminist groups object to this. That is why countless international fora have discussed this, where countless international rapporteurs, people who would describe themselves as social liberals on all sorts of other issues, object to this because they see in this something that is intrinsically and unavoidably exploitative of people. That is the hard reality that it is my sad duty to express on this floor today. It gives me no pleasure that people's feelings get hurt because I tell the truth as I believe it to be. But what kind of representation would I be giving to the women who have been hurt through the exploitation of their bodies by surrogacy, to the children who have been deprived of everything from the nurturing and care and love of their birth mother, their genetic parent, where that parent is permanently sundered from them, their right to breastfeeding where possible, and all of those other things that surrogacy deliberately forecloses the possibility of. What kind of service would I be giving to those people if I did not speak out strongly against this? If I did not, or indeed if Senator Keoghan did not speak out against this? We're using strong language because strong language is required. Because what's before us here is profoundly unjust. It is banned in every other European country except Greece. It is the minister and the supporters of this bill who are engaging in the aberrant behaviour, not those of us who believe that this legislation is profoundly wrong and speak out strongly against it. You know, you lose friends when you stand up for things you believe in and you tell the truth. Your duty is not to set out to deliberately offend. Your duty is always to speak the truth as you know it on the basis of the facts as you have them. But you can't sugarcoat your message out of courtesy to the point where you conceal the important point that you want to make. So I am sorry to be the cause of anybody's sense of offence, but I cannot but tell the truth as I see it. I cannot but call a spade here. And therefore I must reiterate, the fact of international surrogacy is that it exploits the poor. It is proposed to have this legislated for here because domestic surrogacy, or even confining it to EU-based surrogates, doesn't give advocates of surrogacy what they want. And the reason is the economic disadvantage internationally of the women who will be available for surrogacy compared to the economic disadvantage in the EU. There is no other reason. And, you know, it was put to me on Limerick Radio the other day, when I mentioned this point about how even reasonable expenses can run into tens of thousands of dollars, or euro, of course, it'll be in this situation. You know, that's a lot of money for an impoverished woman in Ukraine. And it, of course, is also in a situation where we cannot possibly or properly regulate what's going on. So there will be all sorts of middlemen offering legal services at high cost, and this will be all dressed up as a reasonable expense. But in reality, what we will have is commercial surrogacy by the back door. And it was put to me on Limerick Radio, oh, well, now you're wrong, because American women make themselves available as surrogates as well, and that's not a poor country. How much do they charge? I asked back. Hundreds of thousands?
250.
250,000? Any advance? This is criminal, except it's being made lawful. Yeah, well, it is precisely on this point. So what I am asking the minister to do is to give me something better than his glib response that he sees no reason to confine this to a EU citizen. It is the least that he can do if he wants to pretend, however weakly, that he's not smiling on and countenancing on the exploitation of poor women by those who are in financially an advantageous position over them. That is the reason for this amendment. It's an evidence-based proposal. And I think that those who are concerned by surrogacy, not to say those who have been hurt by it, are entitled to a better answer than that's been given.
Senator Siri Carney, did you indicate? Am I wrong? Yes. No, yes, go ahead.
Certainly did. Okay, so first of all, there's a few smoke and daggers casting of the situation as it's proposed in the bill going on here. For future surrogacies, we will have a regulatory authority who will look at all of the circumstances, get better and better as they move on through the years, which is what I used to think and say about it, that in fact the more experience that regulatory authority gets, the better that they will get at adjudicating and spotting and knowing where people shouldn't go, because parents need to be minded in that. Intending parents need to be minded. But we will have a regulatory authority. So let's deal with the domestic first of all. They will license clinics in Ireland. They will adjudicate on any planned surrogacy before it commences. A clinic that breaches any of the ARA's conditions will be likely to lose their licence, will be prosecuted. All of those things, all of those safeguards that Senator Mullen conveniently just pretends not to see, because he wants to see a particularly dark picture instead of the very ethical framework that is here. So that's the first miscalculation and our convenient ignorance of what's in the bill that is being exposed. The second one is domestic surrogacy does not occur in Ireland to the extent that it may do in the future, because there was no way of severing the rights and obligations of the surrogate mother, who does not want to have lifelong obligations to a child, who does not want a child to have inheritance rights on her family, who does not want all of those obligations. Senator McDougall actually was instructed for the state in a case of those very circumstances. So because of the failure to legislate up until now, we haven't seen what can happen in domestic surrogacy. It is my hope that we will be able to have domestic surrogacy, particularly for the LGBTQ community, particularly for them in Ireland. That there will be opportunities that will open up for them to grow their family at home. Nobody wants to give birth away from and be at their child's birth a long, long way from home. I have family here who flew out to be with me. And you were a long way from home and you thought you'd never come through Dublin Airport. So nobody particularly wants to have to travel abroad, actually. It would have been much better if there was a framework in Ireland. But for as long as there is, and I spoke last week about setting up a support group for parents, and I was shocked by the number of, well, shocked is the wrong word, but I was surprised by the number of people that contacted me saying, how do I become a surrogate? They weren't poor. They were doing it out of altruism. They liked being pregnant. There was a whole heap of reasons as to why a woman knows somebody with a fertility issue and was maybe sussing out what are the situations and can I sit down with this couple and say, actually, I've had successful pregnancies. I could probably carry a baby for you. But I had to say, this is how hazardous this is. If you do this in Ireland, this is what will happen. There is no framework here for domestic surrogacy. So the characterisation is absolutely disgusting, to say the least, in the terminology, and they were right to respond. They've sat through quite appalling comments here today, and provocative comments, and they have done so quietly. And naturally, they were aghast at the characterisation of them and the women who carried their babies. Ireland will be very progressive, very thorough. Last week I said this is a cogent piece of legislation. It is comprehensive. It is also conservative. It is also conservative. Denmark have just announced that they are going to legislate for surrogacy. The Menesson case, and we know we met that family at Easter, in France, paved a way. So this idea that no other country except Greece, that is not true. It is patently untrue. There is a pathway to parenthood through surrogacy in other countries. So it is patently untrue. And then I want to address, there were two women on the webinar yesterday that Senator Mullen, and there were other speakers on it. Other speakers who, out on social media, are anti-trans, anti-gay men being parents. They are vile in what they have to say and in their commentary. They also think that I shouldn't have a voice in this debate. Not real, because nobody should be vested in, that is vested in the outcome. I've news for you. The budget affects everybody in this House as well as everybody out. I am staying to the amendments.
Thank you.
the facts of the matter is, because there has been an issue cast over people who may go to domestic surrogacy and then a characterisation of anybody at international. There are people who think, so these are the people that Senator Mullen is courting. And another day he wouldn't have anything to do with them. They just suit his twisted argument now in characterising everybody in a particular way. And the two women who shared on that webinar, those two women are being exploited for this very argument of anti-surrogacy. They are being exploited. They should be supported. They should be cared for. In fact, in the case of the surrogate, she should never have been a surrogate. And she was a traditional surrogate, not a gestational one, as we are putting in a framework for. Not all those things. And I'm sorry, I know you think I'm going off, but I'm not. This is a record of this House for eternity. And there are children who will read this as adults. So it is necessary that we address back the appalling besmirching of our families, our surrogates, and the stigmatising of our children. It is really important that that happens.
Could I welcome, by the way, to the public gallery the newly elected councillor for Cork City, Councillor Padraig Rice. Councillor, you're very welcome. Thank you for being here. And Tara Ledahull.
Here, there are three things I'd like to say. The first is this. Ciarán, you and I were elected to Dáil Éireann on the same day in 2011. I've sat through and participated in a lot of debates in the Dáil, a lot of debates in the Seanad, as have you. Some of those debates have been very difficult. Some of those debates have been very divisive. Never until now have I ever seen a member of Dáil or Seanad Éireann openly mock people in the gallery. And I'm not referring to his initial outrageous comments. I'm referring to his allusion to this not being the Stella Cinema and people not being allowed to react. And Chair, I want to say directly to Senator Mullen, 13 years I have never seen visitors to Dáil or Seanad Éireann mocked by a member of the Oireachtas. And I put it to you, Senator, that you are an absolute disgrace for doing that today. The second thing I want to say, Ciarán, is this, that Senator Mullen, without any irony, is setting himself up today as a defender of women's rights. Senator Mullen, you are no champion of women's rights. You have sought for years to control women. You have sought to control them through the Constitution. You have sought to control them through legislation. You have sought to control them through dogma. You have an obsession with controlling their reproductive health. You have an obsession with controlling people's sexuality. Can't get married if you're gay. Gay men, gay women can't get married. Apparently today, you shouldn't be allowed to try to be a single father for some reason. You, Senator, are no champion of women's rights. The third point I want to make is to the amendment. The Senator asks why we wouldn't confine surrogacy to the EU. Well, what are you trying to achieve, Senator? Are you trying to say that those below a certain household income shouldn't be allowed to be involved in surrogacy? There are poor people in Ireland. There are poor people all across the EU. And there are poor people all across the world. What about Canada? No. America? No. What about the United Kingdom? The UK isn't in the EU. Now, you've got a big problem with the Ukraine being allowed. Well, the Ukraine is going to join the EU. So I would put it to you, Senator, that my short answer was a polite version of saying that your proposal is nonsensical. Yes, we need to protect surrogates all over the world. And yes, this is a Conservative bill. So we have not done something that lacks any decent rationale or consideration, which is what you're proposing, which is to say, well, it'll be within the EU. A country that left the EU, you're not in. Country that's coming into the EU, we don't want it there, but when you're in the EU, we'll allow it there. We're not doing anything like that. What we are doing is setting up a regulatory authority that will, on a country-by-country basis, and within countries, on a jurisdiction-by-jurisdiction basis, and then on every single application for surrogacy with an intending parent or parents, will go through all of the safeguards to make sure that surrogacy is safe, and that the very real concerns that are raised around exploitation around the world, that they are addressed. But we're not doing it in some bizarre geopolitical line on a map. We're doing it in a considered, legally robust, jurisdiction by jurisdiction and case by case basis. And that is why I'm not accepting your amendments. And in your response, you should apologise to the people in the gallery.
Thank you. Senator Mullen.
I will apologise to the people in the gallery that they are so badly served by such a weak and verbally inadequate minister who has no principles and whose only mission in life is to give the loudest and most influential lobbyists whatever they want to please the media, but who is in no way animated by principles of justice or a reflective approach to inclusivity when it means, when it comes to legislation, when it comes to protecting the weak. No interest in that whatsoever. Probably the worst minister we've ever had. No friend of children with scoliosis, that's for sure, but very, very good at the virtue signalling politics that gets you plaudits in certain quarters. Minister, you have tried more than once in this House to engage in some kind of verbal bluster to demonise people like myself who challenge you strongly. You don't like being challenged strongly. And your PR people tell you that the best way is to come out fighting and to try and humiliate and belittle the person who points out the error of your government's ways. But I'd be delighted to. But you know, before you came in, Caherly Ganevig, I made the point earlier on that Senator Siri Carney was allowed to expatiate at length, not just once but twice, and I'm not going to stand for it, that I would be the one constantly interrupted and asked to stick to the amendment. I'm very clearly replying to what the Minister said, and I will do so. Okay? Now, the first and obvious error that the Minister made was to suggest that I had mocked the people in the gallery. Far from it. I had expressed disquiet at their behaviour. It is not the practice in here to allow visitors in the public gallery to make noise or express approval or disapproval or to try to intimidate or influence members in the discharge of their duties. Okay? That is a clearly established rule, not just in this House, in the Dáil or the Shannon. I understand why people might be annoyed at me. I am certainly far from mocking them. As I've said earlier, I feel great sympathy for the position in which they have found themselves. However, I disagree with surrogacy. I disagree especially with international surrogacy. I think it breaches human rights. That's the reason. And therefore, I reserve my right to say, as I did say, that this is not some place of public entertainment where people can, make noise in response to things they like or don't like or are horrified or express emotion. That's not what this House is for. And it might be no harm if members here remember that as well and not just visitors. The question of whether one is a champion of women's rights or not is of course very much in the eye of the beholder. But what I can say to you is this, Minister. I have always been clear about two things which I believe honestly, and I believe that it is an evidence-based position, that every child has a right to live from the moment that he or she is brought into being at conception, and that every child has a right to be brought up as far as possible by a father and mother, and preferably their own father and mother. Those two principles have guided my public life and my public advocacy in relation to these matters. You may seek to demonise them as, coming from some kind of controlling mentality or some kind of fixation on other people's bodies. But these principles are well understood by people of all faiths and none, by people of humanitarian goodwill, intent and practice all over the world. In fact, these principles were the standard human understanding of things up to a few decades ago. And because I challenge the mores of the times and the legal developments that deprive some children of their right to their very existence, and because I challenge ways of bringing children into being that deprive them of things that you should be seen as having a right to, I won't be told that I'm an enemy of women's rights for doing that. In fact, what surprises me, Minister...
And I'm actually not interrupting you. I just want to acknowledge they're about to leave the room. So if you would give me the indulgence to allow me just to welcome, and you are more than welcome to resume. I just want to welcome the Roscommon, Corner and Ogue, the young people who are here and are witnessing democracy fully in action here today. And I hope you're enjoying the hearty debate going back and forth, and you're more than welcome here. I know you're guests of Senator Dolan here, and I just wanted to welcome you here. I know that you're about to leave, and forgive me for interrupting you, Senator Mullen. You can have the floor again.
I would also like to say up the Rossies, considering I live about 5 miles from the Roscommon border, and I'm as frequently in Roscommon as I am in County Galway. So fáilte roimh agus gonnearna go geallaibh, and you are listening to the robust expression of our democracy, our noisy democracy at times. But it is better to have a noisy democracy than a democracy where people are silenced because of groupthink. And that's why we sometimes have to disagree, hopefully never too disagreeably in this chamber. But sometimes we have to disagree about important things. And we are certainly doing that here today. So, as I said, it is one of the features of my life in recent times has been to be approached by women and men who do not maybe share my views on other important issues, including the right to life itself, but who do see the injustices of much of the other things that the government has been proposing in recent times, including the arrangements around surrogacy. In fact, it was only recently enough after I'd had my hair cut when a woman said from the same salon, "Are you a politician?" And I said, "I am. Am I in trouble?" And she said, No, I admired your stance on the referendum. I was a no voter as well. And I have to say, we weren't always bedfellows. And I felt like saying, well, now that we are in bed together, we might have some pillow talk about some of those issues we disagreed on in the past. So that's my experience, which I didn't obviously say that, but that's my experience, which is that there are people who agree and disagree on different issues of importance, but there are many women who are profoundly offended by this legislation because they see it as an attack not just on womanhood but on motherhood, not to mention, as I said, the abuses of the child's rights in the situation. Senator Siri Carney made, I think, 2 points that I think deserve and merit a response. The first was the don't worry, there's really no reason to fear that we're going into a dark place because we have all the licensing of all of these providers by the ARA, the AHRRA body that's being set up. But how can one have confidence that they won't be as captured by the surrogacy industry as the minister and the government have been by the surrogacy industry? Time after time, the concept of regulation and the establishment of regulatory authorities is really just another word for here's how we permit this in such a way as we don't frighten the horses. So I'm sorry, people will have no confidence that these licensing clinics won't be entirely facilitative rather than restrictive. And I would go further, that so far as international surrogacy arrangements are concerned, there is simply no way that this can be policed remotely from Ireland. And that's another reason why this should be confined to EU citizens if you're going to do it at all. Because the further you get away from this jurisdiction, the harder it will be to have any control of what is happening, no matter what the rules say. You know it, Minister. Senator Siri Carney knows it. Everybody knows it. But it doesn't suit you to admit it. And that's why it makes no sense in many of the instances we're talking here to talk about safeguards and what they might deliver. The international situation will indeed be a dark picture. And Senator Siri Carney made another point that I thought was interesting, which is that she looks forward to the day when there'll be more widespread domestic surrogacy going on here. She didn't go as far as to say, I think, maybe she did on the record, that she looks forward to the day when it's not necessary to engage in international surrogacy arrangements. But it was interesting, the point that she made about one of the reasons why people in our jurisdiction wouldn't make themselves available as surrogate mothers was they didn't want or wouldn't want to have any responsibilities towards the child, financially or by way of inheritance or otherwise. And doesn't that really show what an unnatural thing we're talking about here? Where we want to bring forward an arrangement to enable the carrying of a child in the womb by a mother, by that child's mother, for 9 months, the woman who will give birth to that child, after exchanging even some genetic information or influences through epigenetics, the nurturing, the bonding, so much stuff we know about, and indeed an awful lot we don't know about. And we want to make this available in such a way as that mother won't have any obligations to the child. I think just that goes to the heart of what is wrong about all of this. The other point I want to say, and here's where I agree with Senator Siri Carney. It's not today nor yesterday, to quote the Saw Doctors, that she and I have disagreed on this issue. I remember the first day it was to do with an entirely different matter that was on the floor, being debated on the floor of this House. And I mentioned my belief that a child shouldn't be sundered from their birth mother, and that a child should be brought up by a father and mother, and as far as possible by their own father and mother, and that should be considered socially desirable, always encouraged, and never deliberately prevented, as is what's happening in this. And I would have made comments, but maybe not to any great detail. And I remember Senator Siri Carney, newly elected, took me to task immediately after the debate, because I was unaware at the time of Senator Siri Carney's personal story. And she did so in her admirable but very forceful way. And I just about fended off the verbal onslaught, as I recall. And why do I recall that? Because I have been tempted to think on a number of occasions, because Senator Siri Carney said there that there are people online, and I disagree with them if they are there online, that suggest that she shouldn't have a voice, or that suggest that she shouldn't be part of the... Sorry?
They're your friends from yesterday.
Well, I'll give way to you if you want to tell me who said it.
Your friends from yesterday.
Sorry, do you wish to be more specific? I don't know whether I have a friend or not.
Through the chair and on the amendment, please.
I'm willing to give way.
Senators
I'm
on the
willing to
amendments,
give way
please.
to Senator Siri Carney if she wants to name and shame, and I will criticise such a point of view on the floor of this House. So, do you wish to name the name, Senator Carney? Through the chair.
Okay.
Senators,
you've done that
through the chair.
Okay.
Senators.
Well, let me say clearly that I myself, when I saw the operation of the Surrogacy Committee, and particularly the way Senator Keoghan was treated, was tempted to wonder whether the normal, mature, careful, respectful, deliberative process that we would expect in Parliament and in its committees was being undermined by the fact that personal feelings were so strong around the issue. And I was tempted to think at one point, Senator Siri Carney, that it would have been more appropriate that you be a witness rather than a member. But I corrected my own thinking on that before I ever expressed it, because that would have been the wrong view. You have a mandate. And as an elected representative, you have the same right as anybody else to speak to any issue, to be on any committee, to be part of the normal parliamentary processes. What I will say is this, that any of us that has anything that looks like a vested interest should always declare it, and you cannot be faulted on that score. You are crystal clear about where you come from. I have nothing but compliments for you on this occasion, Senator Siri Carney. However, I will say this, when one has such strong personal feelings in a matter, it does behove us all, as it behoves me when I talk about issues that upset me or that tend to worry me or cause me a strong reaction. One does have to call oneself aside and say, am I being fair to my opponent here, whose feelings may be as strong as mine but in the other direction? And that is why, Senator Siri Carney, the one thing I disagree with you today on around the process issue is you're taking me to task for expressing as forcefully as I need to do so my opinion in opposition to the forceful way in which you express yours. Your feelings are important, but they are no more important than any other person's feelings in this debate. And there are a lot of people.
Please.
Yes, Carrie. And there are a lot of people who don't have Senator Siri Carney's advocacy skills, and who are not elected representatives, and who are not powerful people, who do want to express their concern, and some of them have been personally hurt by all of this. Now, if there are people on the internet who say ugly things, then shame on them. If there are people on the internet who say that Senator Siri Carney shouldn't have a voice, then shame on them. But I'll say this as well. Shame on anybody who says that the people who come forward and speak about this issue from the perspective of their pain, that they're somehow patsies, as Senator Siri Carney has suggested, though not using that word. You know, that we're invited to understand that the people who have engaged in surrogacy and are happy with it need to be heard, and that their feelings are very important. And their feelings are very important, I'll agree with that. But we're invited to think that anybody who has been hurt by surrogacy, there's somehow less validity to their experience. And I would wonder about the logical basis for that, that idea which has come from Senator Carney today. So, I'm sorry she thinks my argument is twisted.
To the amendment, please, Senator.
Sorry, no.
Either through the chair or not directed at Senator Siri Carney.
To the chair for sure, but not just to the amendment, to the charges that were made. Okay? Do we understand each other, I hope? Because I want to reiterate that I oppose the stigmatising of anybody. And this has been an argument, by the way, that has been used against people who oppose surrogacy. That they're somehow out to stigmatise the families involved and the children. No, they are not. I certainly criticise and I stigmatise the process. I believe that people should not have access to this process. I think it is violative of women's rights and dignity and violative of children's very basic and fundamental rights. But where a child comes into the world as a result of a violent act, it is not stigmatising of that child to say that that violent act should never have taken place. And by analogy,
just wandering
by analogy, sorry, Minister, do you want me to give way, Minister?
I've been listening. No,
you're poor enough at speaking up when it comes to giving an answer. No, you're just irritated.
Through the chair for both the Minister and the Senator, if you wouldn't mind.
Here, Clearly Nevy. At his heart, the Minister isn't a liberal at all. He's a totalitarian. He doesn't like it up him, to quote Dad.
That is not to do with the amendment.
He doesn't like being told uncomfortable truths.
That is not to do with the amendment.
And he feels the need to interrupt. Whereas all I have done here... Well, I will conclude my remarks by saying that there is nobody being stigmatised here, but there is a process that ought to be strongly criticised here. And those are my remarks to the Ministers, in response to the Minister's unjust charges and in response to Senator Siri Carney's unjust charges.
Senator Siri Carney, you've indicated you'd like to speak.
Thank you. I just want to clarify one thing. My mother is here in the gallery. I think she made a very fine job of rearing me, so I actually don't need any advice from anybody else. She did a really good job. Thanks very much.
We'll keep the amendment, but thank you for the intervention.
I'd like to speak.
Is this going to be on the amendment and not?
I would just like to say that my mother and father made a fine job of rearing me, but unlike Senator Siri Carney, I need lots of advice from people, and I need it all the time.
That's marvellous. We are going to keep to the amendments and a little less about our parents and who is not giving us advice. Does anyone else wish to come in, or are we going to on this amendment? How stands the amendment? We're on Amendment 9.
So Amendment 9 is being pressed, I think.
The question is that the amendment be made. Of those in favour? Those against? I think the amendment is defeated.
Vote all.
Vote all.